Mr. Mahmood,
My lord, something has happened which one, we have filed an IA for substitution, and that was withdrawn due to raising objection by other party with liberty to file a fresh IA, and fresh IA has been filed. But when the withdrawal order has been received by us, certified copy, it is seen that your lordship has passed the order in main case. The entire testamentary appeal has been disposed of. So it will be a very dangerous situation for us.
where is the order for the testamentary appeal?
Testamentary appeal is pending. In the meanwhile, the testator died, and then his legal heirs came for your lordship. But others have filed an petition.
Is there any order in the testamentary appeal?
In the number has been given IA, but order is shown as testamentary appeal has been disposed of. There is no connection at all with the IA. IA is only for substitution of the legal heir. Now will be the administration number 1, 2, 3, etc.
You check out if there is any order in the testamentary appeal.
We have checked up.
If there is nothing, then
That-
file an I will correct it.
Lordship, we are mentioning with this IA as well on Monday,
Monday, we'll have it on Tuesday.
because other party is creating some problem because of disposal of the testamentary. Other party, in that case, there was some interim relief for us. So when the testamentary appeal has been disposed of, so they are now creating some problem.
How?
That is, they want properties in our possession.
So-
They are men and mighty, very strong in men and money power. So
We'll have it today.
today.
Today?
But if it is not listed, then other
Don't
party
say that.
today. I think it will not be proper because other parties can remain absent. They do not know. That is on Monday.
If it is a mistake committed by the court, I'm not concerned about the other part. But if it is not a mistake committed by court, then obviously,
Okay.
let us see that.
Hello.
We'll have it today.
Yes, I understand.
mention for listing of IA.
Early hearing. Okay. When?
Tuesday.
Why? No Tuesday business. Early hearing, let us go to on 10th of June.
For listing notice, arrested
For
long pending from 1/9/2020.
for what?
But the order is
Hearing. Hearing?
order. Maybe come in order.
Why? Is it fixed for hearing?
Second time order.
You want the matter to come up for orders. Okay. Let it be on 10th of June. At the request of the learned counsel appearing on behalf of the appellant, matters can adjourn to be listed after 3 weeks.
I beg to mention item number 46.
Hmm.
Alert. This matter, the case I thought to be transferred is dismissed for default. So I pray that I may be allowed to withdraw this transfer petition received.
What has happened?
The case I thought to be transferred, madam, is dismissed for default.
There.
There.
It has the case out there has been dismissed for default.
Yes.
Then why you are withdrawing this?
But my lord, today, my lord, there is no case pending. The case is dismissed. So this transfer petition, my lord.
Are you filing an application for restoration or
No,
not?
I am the respondent in that case, madam. that case that is
Okay. Mr. A.K. Gupta, the learned counsel appearing on behalf of the petitioner submits that taking into account that the proceeding being proceeding
title suit matrimonial 15 of the 2021.
pending before
Additional District Judge Margareta no,
additional district judge Margaret have been dismissed for default, nothing remains in the instant proceedings to be transferred. He therefore submits that he may be permitted to withdraw the instant petition. And if the respondent herein files any application for restoration, liberty may be given to the petitioner to again approach this court. Taking into account the above, the instant petition stands closed on withdrawal. However, the petitioner would be again at liberty to approach this court.
okay.
Who is out of station? At the request of the learned counsel appearing on behalf of the petitioner, appellant, the matter the petitioner. What is this type of petition? Huh? Then there are many other lawyers out there. Who has filed this revision for? For what? What order? These are simple things. Don't mention.
Prayer for listing lordship in MEC appeal lordship for order lordship.
Okay. 10.
Another was same lordship.
10.
Your Lordship, I have filed an IA in connection with the MHC appeal for passing an order of compromise. Therefore, I pray for the listing of the IA with the item number 37 of post list dated 27/5/24.
Of? Was list dated?
27/5/24, Monday.
You want to bring that IA?
Yes, Lordship.
Okay. It has been informed. No, okay. Permitted.
Okay.
27.
May I please, Lord?
Hmm.
Number 5.
Okay. Before any other bit. It'll come up.
But you have filed one IA for correction of an order. Let it be listed on Monday.
What happened?
There is one typographical mistake
Oh.
in the order. So, Lordship directed us to withdraw an amount deposited by the appellant, but in the order it has been reflected as the appellant. Mistakenly, there has been a mistake in the order.
You filed that IA?
Yes, already
When?
I filed an IA.
When?
On 20th May,
20?
Yes.
Okay. We'll take it up today.
on Monday, Lord.
Why? It's only mistake of appellant respondent only.
Yes.
So what is the problem? Take it up today. Yes.
Item number 43 of Sahib figure that concern the other party. He proceed the update the matter at
What?
update the matter.
Why?
Whatever the another
Why should I upgrade it?
if possible.
No, absolutely not possible. There's already a list out there. Question of upgrading does not arise. No.
Public.
May I please, Lord? I back to my item number 10, Lord. Item number 10, Lord.
Hmm.
Okay, engage some to alarm mode to get some personal lecture. Can you add on the method to
Okay, at the request of the learned counsel appearing on behalf of the appellant, matter stands to be listed, adjourned for 4 weeks.
May I please, Lord?
Hmm.
Lordship,
You're
Next.
challenging what order?
Order, Your Honor, between page number 48, sir. I filed one petition, Your Honor, Lordship. Under order 11 rule 14 that was rejected prior.
Yes.
That Your Lordship, that document was
Why do you need that document?
yes, Lordship. This is a original suit is between landlord and tenant, Lordship, and that tenancy came into existence by that document, Lordship. And contents of that documents are very vital to
Why?
Lordship may kindly come to that
You have a
document,
photocopy of that document?
Yes.
You have a photocopy of that document?
Yes, I have that.
You have
And
enclosed?
I have
Have you enclosed that document here?
Yes, sir. I have enclosed.
Where?
The document is Lordship in page number 25. And that document is admitted by them, Lord. In their deep, Lord.
Yes. Why do you need this document?
Yes, Lordship, because main dispute was regarding enhancement of rent, Lordship. From 900, they have that plaintiff enhanced the rent up to 5,000, Lordship. But Lordship, in this document,
When did they enhance?
enhanced in 2018, Lordship.
What? How does it have relevance with this document?
Yes, Lordship,
This
because
only this 900 will be effective only for this agreement is for 3 months, 3 years.
but Lordship in page number 30, Your Honor, Lordship,
Ah.
in that same document in clause number 4, Lordship, there is a provision how that enhanced rent will be fixed.
As per the prevailing market rate.
Yes, Lordship, that
Yes.
is not done. They have
Then you should have filed a suit for the standard rent.
Lordship only this WS Lordship we have argued that point, Lordship.
Now, understood. You may have to ask for the standard rent. You didn't ask for. How is this document
At that
relevant?
point of time, Lordship, they have filed
He increased in the year 2018. This agreement is of the 2009. Then
and Lordship, one more thing, Lordship, we
and why did you move this application so late? After your evidence is over.
no, Lord. Our evidence yet
You are DW.
just after closing of cross-examination, Lord. They have admitted about execution of this document. And we deposited 50,000 as security deposit, Lord. That is denied by them. And in clause 8 of that document.
Now you don't have an original of this.
Yes, Lord. I don't have, and in WS, we plead that point. Originally is not with us at the time of evidence, Lordship. That we call for, and that is stated in our
Heard, Mister. Your name?
Ken Cody.
Appearing on behalf of the petitioner. To notice, making it returnable on (24/6/2024). Steps be taken by way of registered as well as usual. In addition to that, the petitioner is also directed to take steps by the dusty routed to the registry of this court and file an affidavit of service. First, the steps by registered as well as usual shall be taken within 2 days from today, by Monday. Monday, give the date. This is an application under Article 227 of the Constitution challenging the order dated 5/15/2024. Why you are approaching today so late? What happened? DW, what has happened?
Lordship, we filed one application first. Hereafter, Lordship, we paid for secondary evidence under section 5.
Then
Then it is rejected by this order in February, Lord. And we,
where is the application for secondary evidence? There is no order.
in the same order, Lordship, that is also rejected.
And this is only for calling for the originals of the agreement. This is not for
Alternate prayer
secondary
was
evidence.
here, Lordship, petition number.
What has happened in the meantime? You have approached too late. No stay. We'll give you an early date.
Lordship,
No stay. Sorry. This is an order of 15 to 2024. Date was fixed on 33/2024. We are almost in the end of month of May. There is no explanation why you have come so late. No
we
stay.
want to exhibit this document, Lordship, it is allowed.
I can't help you. Why have you come so late? No stay. I mean, you must be very happy that I have issued notice. Yes. You want an early date, I can fix it.
Lordship, actually, it is from I take.
Take steps by way of the stay. Can't help it. When is the next date fixed?
It is 21. 21.
6. Okay, before that, we'll have it on 19/6. Steps by 19/6 to the first. No. Taking into account that the order was passed on 15 to 2024 and the has been a considerable delay in moving the instant application. This court is not inclined to pass any order of stay of the suit without at this stage.
Mistake is here.
21/6, huh?
Small mistake is here regarding numbering of the annexation. Direct. Correct.
21. Take your steps by the stay. Next date is on 21/6, na?
Yes.
I fixed it on 19/6.
Nine.
9. Yes. What are you challenging?
Whether the proceeding before the learned session district judgment, Maji has been challenged in this case.
Why? Which order you are challenging?
My lord.
Which order you are
The
challenging?
entire proceeding, my lord.
Huh?
Entire proceeding of the matter settled to D 3 of 2022.
T oblique?
Page Annexer 1, my lord,
Why?
page 10. Only
Why?
because my lord, paragraph 3 of that plain, my lord, page 11. That the marriage between the parties was solemnized on 27th day of November 20
Paragraph?
at the
Paragraph
3, my lord,
of?
of the plain page 11.
In between the parties was solemnized on 27th of
7th
November at
Both parties,
both
as
the
per
parties'
prevailing
residence
missing
as per
customary law.
prevailing missing customary law. Then
Now, your lordship kindly peruse my lord, section 2 of the Hindu Marriage Act.
what does it say?
It says, my lord, when the married man, notwithstanding anything contained in subsection 1, nothing contained in this act shall apply to the members of the scheduled tribe within the meaning of the clause 25 of the Article 366 of the Constitution, yeah? Unless the central government by notification to the official gazette or otherwise directed. And the parties are governed by the customary laws. So Hindu laws, the petition was filed for divorce under section 13. This is not applicable unless there is notification issued by the central government. Despite that, my lord, the cognizance has been taken, notice issued to the petitioner, my lord, wife.
Where have you challenged the jurisdiction?
Yes.
Customary. Now, how will I know whether there is any notification or not?
My lord, I have searched for that, my lord, but I could not find.
Yes. What do you say? Hmm. 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 Yes, yes, please, please. Hmm. Just 1 minute. Huh? Yes. Page number. Hmm. Yes. That the parties admittedly follow the Hindu religion and the missing tribe is a Hinduized tribe and they have some come under the influence of Hindu traditions and customs. Therefore, social philosophy is social interpretation is customary. Understood. All these things are understood, but how do you extend to the scheduled tribes as defined under section Article 366(25)? How do you extend it? No, that is another thing. We'll go by whether it will be relegated only to customary law or not. That is another aspect of the matter. But the fact is, let's see the wording used out there. Notwithstanding anything contained in so and so, nothing contained shall apply to the members of scheduled tribe within the meaning of clause 25 of Iman unless central government. So, anybody who comes within the ambit of a scheduled tribe, whether professing whatever religion or not, isn't it the requirement for having a notification because of the customary law? Understood, it is being followed, but nobody has raised this
Yes.
question. What do I do? Yes, please do.
Technically, we have filed a petition before the London State District Judge.
Yes. Hmm. Hmm. Paragraph 6. Paragraph 6. how do the court take note of section 2.2? In view of such a clear finding, it is not possible to hold section 2 of the remand excludes the present parties from the application of the said act. Up to paragraph 15 of the judgment in this. So here this court does not answer this question. Now it was said that this Hindu marriage was or Ati was brought within the order, dispute order, only after the amendment made in the year 2003 and the marriage took place earlier. So therefore it didn't go into that question. No, because that was there. They would come within the Hindus because they were not the. Otherwise, if a person carried out, Hinduized culture or that, yes, there's no quarrel. But how do you exclude? How do you take care of two? The two judgment that you take was so satisfactory, so clear. What do you say about the special marriage? What do you say? Because see, that's why I was looking at special marriage act. There is no So any marriage it come under the because then also one can ask for divorce. What do you think? Maybe not under the Hindu marriage, but what about the Christian marriage? Because they also have similar conditions. No, obvious. Because customary law is okay, but then also notwithstanding anything contained any other law for the time being in force, they to solemnize the marriage between each person in at the time of the doing consent. Neither party has a spouse living, neither party is capable of giving valid consent. Male has completed the age of 21 and the female the age of 18. Is not within the prohibited age where the marriage is recognized in the state of doesn't put the party it is a clear custom in relation to a person belonging to a tribe which you are the state government and modification is specified as applicable to the members of the provided that no it shall be related to members of it. Did you have a marriage certificate? Did you have a marriage certificate?
No.
Well, in marriage act, you require certificate. This marriage took place when no, when was the marriage?
2020, 2020, November.
2020, I think you need a without a marriage certificate. The marriage has been solemnized. The marriage is certificate. And what is the missing customary law?
Well, I have approached law research of our High Court. They told me that the entire process is on my draft.
Huh?
There is in fact customary law, but that was on draft
By?
by the law research of our time. I have a procedure. There is in fact diverse customary diverse.
It's a different thing. Not on that. It can be remedied. You're referring to that Pratibha thing. How does the thing is being taken? Is that the issue out there? Mhm. We don't- What happened? You're only given half of the and then we'll do one thing, we'll hear this matter again, substantive detail, because this is a very law involved, and time with this, the Special Marriage Act is not involved, because without a marriage certificate, can it be so? Because Supreme Court says that there is a requirement of a marriage certificate. And this came sometime around 2011. So now it is mandated you have to have a marriage certificate. And this marriage having taken place in 2020. Here the Delhi High Court gives a different interpretation or a flavor that this is a this section 2.2 has been only brought in for for protecting the customary right. But if the customary rights does not have a procedure for divorce, you can't non-suit them. Then in that case, once the jurisdiction is being, there might be a jurisdiction or may not be. What you are saying, whether it is Hinduized or not, that is also a question of proof, which you have to prove it. This court cannot do it. So obviously, the petition cannot be held to be maintainable for that. We may have to dismiss the petition asking you to do it. But first, we have to come to an interpretation as to whether 2.2 can be overridden if the scheduled tribe have adopted a particular custom. It may be a scheduled tribe may have taken a Christian. So then you may have to go for a divorce under the Divorce Act, the Christian divorce. So you see in all those cultures, they may also have something. Because this was made, there was no change out there. Chalo. Okay. Ah. No, understood. But the thing is, don't know about others. Any judgment passed in a hurry in this matter may have far-reaching consequences everywhere. We may have to look into many aspects, like the missing laws which are there, as to whether they have a divorce culture. Heard the learned heard Mr. P. Shaker, the learned counsel appearing on behalf. And Madam P. Shaker appearing on behalf of the respondent. The issue involved here pertains to as to whether the parties herein who admittedly belong to a tribe, scheduled tribe, in terms with Article 366, 25, bracket 25 of the Constitution of India, can avail remedies under the Hindu Marriage Act 1955 to seek a divorce. The said for deciding the said aspect and also taking into account its ramification, this court finds it relevant to implead the state of Assam, represented by the director social. Whom should we make? State of Assam, whom? Huh? Social Welfare Department. Represented by the Commissioner and Secretary. State of Assam, represented by the Commissioner and Secretary, Directorate of Empowerment, having its office at Dispur, Guwahati, 781006, as the respondent number 2 in the instant proceeding, as well as the Union of India, represented by the Secretary to the Government of India, Department of Social Justice and Empowerment. What is that department? Union of India Department? Which department? Social Justice and Empowerment, having its office at New Delhi as the respondent number 4. The registry is Mr. P.J. Shaker, the learned counsel. Miss, you appear on their behalf, you take notice. Who is he? And for the union, you. Mr. R.M. Das. Mr. R.M. Das duly accepts notice on behalf of the respondent number 3, who is the standing counsel of the Department of Social Justice and Empowerment, Government of Assam. And Ms. K. Pukon appears on behalf of the Union of India and accepts notice. Mr. P.J. Shaker, the learned counsel, appearing on behalf of the petitioner, shall take effective steps for service of extra copy to the said counts during the course of the day. List the matter again on 20. 20 is open, na? 20 June 26, 2024. For further hearing of the matter and be shown as part of. You just find out that because once Otherwise, we can override Hindu. Then whether it is Hinduized or not, that is a question which you have the different. But first, how do you take care of? There might be an interpretation now. The court may have watered down to it, and that is what from the Delhi judgment. But the Supreme Court judgment is there, but it was a very important provision. Well,
All right.
you give a copy to Mr. RM.
Fine.
Union of India responsibility.
My lord, in the meantime, may be directed to produce the notification if there is any matter. Let me observe that.
Yeah, on that. That's better than it.
All right.
Are you saying that there is a?
Well, perhaps,
Are you saying
perhaps,
no? Are you saying it in your?
no.
Mr. Appearance at finishing out the escape out of the
Huh? Union of India
area of
filing an appeal within time. Delay. Delay condone.
stay,
I for what? Stay.
stay.
How much amount? You want to stay or not?
We want
Huh? Why did he has enclosed the judgment of the year? What is the point involved here? Oh, that is the point. For that they have enclosed the judgment of the Supreme Court. Annexure M. Yes, what do you want? You want an adjournment? Better adjourn it. If I am passing an order against the union, then I ask Mr. SK Mehdi to be prepared next time. We can.
that maybe fixed on like
One?
I keep
Why? Some special day. At the request of the Council for Apple and Matters and adjourned to be looked with after 2 weeks. Yes, what is it? LA appeal. Okay, appeal is it. There's a delay condone. Appeal admit, call for the record. Mr. Enso appears on behalf of phone numbers 1, 2, and 3. Extra copies of the memo of appeal will be served upon her during the course of the day. Upon receipt of the record, the matter will be listened for hearing. Yes, what is this appeal? Appeal for what?
For
Enhancement.
enhancement.
Huh? Why?
As per section 4A of the Workmen's Compensation Act, the claimant is entitled to get.
What is that IA for? IA for?
I is condoned by.
Delay condone. Let me call for the record to notice step within 70. Upon receipt of the records, matter be listed to him. About completion of service and receipt of the records. Yes, anything happened? Have they broken the wall or not? Why? What is this additional affidavit?
My lord, by this additional affidavit, we proceed to record our status of
Yes, what is that?
protocol.
Who is Bikram Singh Lokar?
Plenty. Plenty.
Why did your police not inform the executing court? Why? Huh? They should have informed the executing court that they cannot. And in how many cases do they do? Huh? The Deputy Commissioner of Police Crime he says that if that be so, when there was already an order, he initially said about election. Election is over long time on 7/5. After order only on 17/5. Then what stopped him from doing it? Anyway, yes, what did you file?
My lord, an additional affidavit.
Yes.
Whereby we have annexed the copy of the latest Jamabandi, wherein the name of the appellant are shown.
Forget about Jamabandi. We are not concerned with Jamabandi.
Then,
Show me
my lord, the
what is the document.
copy of the registered keep deed number 5245/1958 at annex 17,
5245.
and copy of the registered cell deed number 3869/1959.
This sale deed is executed on. This is what is the land?
My lord, from
Ravindra Chandra Das,
454
Prabhat Chandra Das, both sons of
458.
so and so. Tony are the sons of my younger brother. I have no issues. And
Then, my lord, 460, lord will find the
454. What is this?
454, my lord. This
This
is
is
the
what?
deed, the copy of the deed number 3869 of 1959. That is the still registered
Mr.
sale deed.
Sharma, what was your dark number? 61?
691.
691, na? And patta number?
My lord, 366 new and 144 old.
144 old.
And 366
That
new.
is the patta number.
Yes, KP Patan.
Patta number is what?
144 old, 366 new.
The plaintiff's land.
Yes. Still
144 old. Patta number. Patta number 144 old. And 366 new.
and prior to 144 old, it was 38. Because this is of the year of 1959, my lord.
Prior to that, 38.
38
38 is the old.
old.
Okay. And what was the dark number? Initial dark number?
Initial the 720, my lord.
720. Oh, then what was the dark number when it became 144?
Then, my lord, 493 old.
493. Then now
And after settlement, 691 new.
691 new.
It was completed in
Okay. 691 belongs to whom?
my lord, Jamavanti Sahi. His name is reflected as Patta number 28, 20, and the appellants are 26 and 30.
691
That is from page number 445.
is 2 bighas of land.
Lordship, in page number 447,
445 is
জমাবন্দী, my lord. 691-306
ওঠৰত ইয়াৰ চক্ৰ বিষয়াৰ তাৰিখৰ হুকুমৰ মতে জাগৰ জমিৰ 13.8 জমিৰ পদত শংকৰ কুমাৰ দাস, ভূপেন্দ্ৰ চন্দ্ৰ প্ৰসাদ
447, my lord. Serial number 26 is one of the appellant.
So, in these 2 bighas of land of Dag number 691, he has 4 kathas.
Yeah.
There's no quarrel with that. চক্ৰ বিষয়া চিহ্নময় নিখনক And what are your name?
My lord, serial number 26, Sri Shankar Kumar Das, one of the appellant.
Huh?
Page 447, my
Shankar
lord,
Kumar Das.
one of the appellant.
And
Then page 448, 28 is the plaintiff, the respondent to this appeal, and 30 is another appellant. Deepak
another
Order.
appellant.
Another appellant, 30.
So, we are concerned with Shankar Kumar Das and
And Deepak Order.
Dibakar Das. So, their name is against how much land?
My lord, it was the first order, co-order.
No, no. Horuzoni Das. Who is Horuzoni Das?
This is defendant number
29.
this is defendant number.
Appellant number 3.
No. She is not an appellant. She died, who died prior to the incident.
Okay, her name is there.
Yes.
Okay, her name is there. She is the mother of. So it is now you have got the title, right?
Yes.
So this Dibakar Das has now 2 katha 10 lectures. And how much this person has?
My lord,
What is the
very
Shankar
first order.
Kumar Das?
My lord, 13.38 R land.
Where?
The order of at page number
জমির
445.
পট্টাদার লগত And what is Prabhat Chandra Das? He is a party here.
No, he is our petition. Our petition.
No. Kindly see the 445. 13.38 R জমিত পট্টাদাৰৰ লগত উত্তৰদায়ী সূত্ৰে 1 নম্বৰ শংকৰ কুমাৰ দাস পিতা মৃত ভৱেন্দ্ৰ চন্দ্ৰ দাস আৰু শ্ৰী প্ৰভাত 2 নম্বৰ চন্দ্ৰ দাস পিতা পদ্মৰাম দাসৰ নামত নামজৰি হয়।
Yes, my lord. The appellant number 2 is the son of late Prabhat Chandra Das. And Sarojini Das was the wife of Prabhat Chandra Das.
Prabhat Chandra Das.
Yes.
Okay. Now, instead of Prabhat Chandra Das, Prabhat Chandra Das' name has been struck out. Na? So, instead of him, these 2 katha 10 lectures has been made.
In it.
You see, there are 2 names, Shankar Kumar Das and Iman.
Yes. Shankar Chandra Das was the son
So,
of Bhavan
you
Chandra.
see, 13.38 R is how much land?
1 bigha.
1 bigha?
1 bigha.
Yes, 1 bigha.
1 bigha.
So of which, so this is 1 bigha.
1 bigha.
So therefore, out of these 2 bighas, the appellant's right is to 1 bigha.
Yes.
Is it? To make it simple, the total land in 691 is 2 bighas.
2 bigha, 1.06 lakh.
That is too less. Let us not go there. Out of 2 bighas, your right is, appellant's total right is 1 bigha. Because initially Prabhat Das name was there
Yeah.
against that 1 bigha, which makes it was between 2, so it was 2 katha 10 lechas each.
Yeah.
Now thereafter Prabhat's name
Like,
struck off and
Sarojini and
29
Dibakar.
30 came in and 29 died, so 30 becomes the owner of the share of Prabhat Das. So this is 1 bigha of land. Now he has 4 kathas. There is no quarrel with that.
No, my lord. What he said in the plain, we on the very first day when the ad interim injunction was granted, we challenged on the aspect of this total quantum of land. He said 1 bigha something kata something lesser is covered by tag number 69. We said no, it contains 2 big.
No, it's
So
okay.
that's why in the commissioner report also, the first point is what is the
Now,
quantum of
who
land?
has that one katha land? Who has it then? In whose name it is? That 1 katha land? Somebody has that 1 katha. See, we are having this. What? So that 1 katha is remaining is with Sujit Singh. Well, his serial number is what?
My lord, 26 at page 447 and 30 at page 448.
No, 26 is you.
Yes.
26 is you.
26 and 30.
26 and 30 is you. There's no quarrel with that because 29 is dead.
No, yes, she died.
So here, where is that 1 katha left? Binoy Das. Who is Binoy Das? Dhruva Chandra Das. So Dhruva Chandra Das is your vendor. So Dhruva Chandra Das, Kunjat Dhar Das, and Binoy Das. These are the 3 vendors. These are all, they had 1 bigha. From there, 4 kathas has been sold to him. So remaining 1 katha is with them. It's okay. We are not on that. So that is how it is. So one bigha is still with the vendors of your plaintiff. 1 katha. Okay. Now, you have not challenged their deeds. You have not challenged their title. Huh? No, Mr. Sharma, are you challenging their deeds? Let us see what is in the plain.
In the plain, there is no challenge made to that.
Shankar Kumar Das and Dibakar Das. This is by whom? There is another suit.
Yes, my lord. By the very first document that we have filed along
What?
with our
Now, what
affidavit,
is he
my lord.
claiming? Wait. What is he
So this
claiming?
Bhubo,
Declaration of
Kunjo, Binoy and
confirmation.
Binu,
declaring plaintiff's right over title. So he is asking for B, which is 4 kathas of land. 4 kathas. Declaring confirmation of possession over the remaining portion of Schedule A land. Schedule A he has put as 1 bigha. So that is on the west side. Which is Schedule C, I suppose. You put it here. East plaintiff land, west. Then does your boundary, Schedule B boundary, what is to the west? Here, performer 691. Who are the performers? Performer defendants are Amulya Das, Bhaskar Bhushan Das, Joy Das, Das, Deep Das, Utkrishta Das. Where is your Jamabandi, Mr. Sharma? You are saying about 1 bigha of land. There is 691 contains more land, I suppose. 2 bigha. Because if you see, anyways, kindly come to page 42 of his petition. No, his petition. Main petition. 42 is your boundary. To the east of Schedule B is the land of performer defendant. Isn't it? To the east is the performer defendant. Okay. Now, from the Jamabandi, you have not challenged the Jamabandi. One thing is very clear from that document which he has brought in. This 691 dag has 2 bighas, of which 1 bigha has been shown against your vendors, initial vendor. And from there, you have purchased 4 kathas. So remaining 1 katha must be there. Equally, in 2015, the father, the Sankar Das and Prabhat Das name duly appears in that Jamabandi against 691. Understood? Whatever may be. Hmm. Hmm. But you are not challenging anything, na? That is understood, but you are not challenging the give deed. They have already challenged it. One bigha. So there is already a suit. No, Mr. Sharma, only one thing. These 4 kathas or 3 kathas, whatever may be, he has 4 kathas on papers, which is there. There is a sale deed back. And he has an agreement for sale with another 1 katha. That is another aspect of that. Oh, well, yeah. Now, these 4 kathas, you said on the east there was no boundary wall. Chalo. On the west, there was a boundary wall. No, west there will be a boundary wall because that is, he may not have initially beyond the 4 kathas, but beyond the 5 kathas, you would, because then you have 675. There is no boundary wall. Huh? So on the west, there is no boundary wall. Chalo. Then on the north, there is a boundary wall. Okay. Then on the south, huh? Bamboo fencing, and you have put a gate. Okay. Then on the east, they have put the boundary wall. Okay. Have they put anything on the south? Not whatever may be. Now on the south, we are concerned with only the south. I am not concerned with the north, east. That is a suit which will be there because here we are only concerned with the mandatory injunction. Mandatory injunction is only in respect to the south. You have any photograph?
My lord, from our side.
Yeah.
The southern side is clearly reflected. That's the highway.
What is this? Construction?
That is his building.
Or
He
this
has
is...
put those building materials in front of his house.
No, no, this is the constructed wall. This is your building.
Yes.
No, no, whatever may be, is this the building? You should have a photograph of this. Give it
No,
me.
no.
Is this the building which is being under construction? It is under construction.
His building matter.
Huh?
This one. Very much.
No,
correct.
you can't
This
go.
is the-
Where is your resident? Where? No, where have you given this? Your building here is different from what is looked from here. This photograph which you have given.
That is an aerial photography.
Huh?
Whatever other side has found is that is a sort of aerial photograph. Satellite.
Understood, but it doesn't show any construction in this type of thing. This photograph which we have given, old photograph. Okay. Now this photograph is this. Now this gate, is this the gate which we are quarreling? This gate which she has given that photograph? Is this the gate?
My lord, that is the plaintiff's gate, my lord. That is the plaintiff's gate installed by the plaintiff. Yes.
Anyways, Mr. Counsel, where is your land in this photograph?
I could see.
You just find out. I'm coming in 5
Yes, my
minutes.
lord.
And Mr. Sharma, you have these photographs which he has just given. Have a look at it. And let me know.
এইটোখন এক চাকৰিটো খুব ডাঙৰখন চাওক। আমাৰ আমি এতিয়া 21 ৰ এখন এয়াৰটেল My lord, we are on the eastern side. We are on the eastern side.
Update.
But it was a map photograph clicked in the year 2021 to the instituted in 2023. So factual situation of the land is somewhat different. As on 2023, on the date of filing or institution of the suit. My lord, I want to refer page number 460. And also to the Amin Commissioner's report. I have annexed my
It is in the. It is in which area?
Kodilapur Gaon. Kodilapur.
What is this CIE new campus? So you are having a new campus up there. And what is this boundary, Mr. Sharma? On that there is a boundary of some thin wall or something in your map. There's some form of a boundary. Hmm. Huh? Hmm. Show me that. This thin boundary is yours. Boundary wall is yours. The thin sheeted boundary wall. That's your. You see this 310 picture. You have this boundary of this particular bamboo. Now, this bamboo. Hmm. Hmm. Where is the wall? Still bamboo, 610 bamboo. This is 1010. There's a boundary wall. You raise this boundary wall. This boundary wall is yours. Show it to him.
We denied, my lord. As on 10-10, we have not constructed any boundary wall.
Chalo.
He put only a single
This
deck,
is
my
not
lord.
your boundary wall also. Chalo. You have not
No,
constructed.
my lord, the point is that on 10-10, his allegation is that on 10-10 we have constructed the boundary wall.
You
But
say
on
that you have not.
No, on 10-10 we have not.
Okay. Now,
Prior to the institution of the suit, there was a boundary wall, and that
that was a
construction of
brick
the boundary
boundary.
wall,
There was a brick boundary wall prior
yes,
to
my
this.
lord, and he has not put under challenge. He has not challenged that. He has
Okay.
not sought any recovery of poet.
He has asked for recovery of possession or not. That is another aspect. But this boundary wall is yours, which is there. Show him the picture of 1010.
My lord, on the southern side, that is the what the learned trial court orders, that on the front side. On the front side, there is no any boundary wall. Photographs reveal.
So what is the problem? Why you are filing an appeal then?
No,
If
my
there is no boundary wall at all, then why you are filing an appeal?
So, my lord, on the curve of this demolition of the boundary wall, he actually wants to make a easementary right over our land on the eastern. That is the problem.
No, whatever he was using earlier, that is the only thing he wants.
No. His version is somewhat else, man. What the photographs reveal, that his building is one side, that is the southern side is bounded by NS 37.
Hmm.
And there is also a gate in NS 37.
Hmm.
He has put that gate.
Hmm.
Today also it is admitted that it is the gate put by him. But he is not accessing through that. We don't have any objection. If he access from NS 37, directly take gate which is shown in the picture on the photograph. And he wants to demolish our home. And that was prior to the institution of the suit. The FIR lost by him.
Mr. Sharma, you have the photograph of 1010. Give it to him.
But these photographs are also not relaxed with the plane, my lord.
Because these happen after
Non-amendment is not, my lord, till date.
we'll look into that.
Matter is of the month of October. Now it is May.
Are these boundary walls yours?
Not. My lord, the north side is bounded by land of Zehrul Islam and Moinul Haq.
Hmm.
In Schedule A, he's saying this is the northern side.
Okay.
So this is not our boundary wall. And this is the east. East land of Proforma Defendant 691. That is our land.
It's okay.
So
No, if you have
eastern
put
portion is ours.
no, if you have put that boundary wall up in the east, I'm not concerned.
Yes.
I'm only concerned, did you put any wall on the south?
No, man.
Because south, you didn't, though your land does not go to the south.
Yes, man.
It is always to the east.
East.
So any land, anything done, I'm not concerned in this matter, obviously.
Yes, man.
I'm only concerned with whether did you put any boundary wall on the south.
No, man.
So then what
That's
is
why, my lord.
no, if it is so, then what is the course of filing an appeal before this court, taking into account that the wall which was directed to be demolished is on the south?
Why, my lord? The point is,
Hmm.
when the application for mandatory injunction was filed,
Hmm.
there he made the allegation that we have constructed the wall in such a manner which surrounded the entire. And there are two buildings, B, Schedule B, and Schedule B. In Schedule B, as per the statements made in the plane,
Hmm.
now there are two buildings, my lord. Lordship will find para 9 of the plane at page 34 of the plane.
Yeah.
Para 9 may be seen now.
Hmm.
Page number 34. That accordingly the plaintiff accordingly obtained permission for construction of RCC building over the Schedule B land and also in Schedule C land, which falls in the western side of the Schedule B land, and accordingly two RCC structures has been constructed over the portion of Schedule B and Schedule C. Out of the two RCC buildings standing upon the said land, the plaintiff along with his family resides in one of the buildings and the other is under construction.
Hmm.
So there are two buildings. So in Schedule C, he has no any title,
No, it's okay. We are not concerned with Schedule C is on that side.
and his allegation is there.
Hmm.
We have constructed the wall in such a manner now which surrounds the entire building in the mandatory injunction. So admittedly, it is a boundary. And the now the
Mr.
point is,
Sharma,
my lord,
Mr. Sharma, if you see this one, this document, you will see on the west also there is some form of a boundary. all along is your bamboo fencing. On the east also you had a bamboo fencing. No quarrel with that. On the east also. So every portion of the land. Now, this bamboo fencing area is a composite area of 1 bigha. Not a year. No, it's okay. But it was a composite area of 1 bigha. So therefore, on the east also, on the west also, you had a boundary. Some form of a boundary. On the south, you had a boundary. On the north, there was no such boundary as such. On the north, there is no such boundary. On the east, there is a complete demarcated boundary. Isn't it? Now, what he has done, as per your allegation, he has made this on the east as well as on the north also. Hmm. Now, you are staying in the western side of that land, meaning thereby you are staying in the western side. You may use the one entrance by which it is on the eastern side, but which is to the south of it. Now, Mr. The council out here says that they have not constructed on the southern side. They have only constructed on the northern side, whether it eastern side. Whether it has been done legally or illegally, it's a different aspect. But on the southern side, they have not constructed. They say, so if they say that there is no construction, let the plaintiff break it. Let the plaintiff break it. I give you the permission. Let the plaintiff break on the east southern side, because they have not constructed.
Yes. Yes, my lord. It should be confined only to the south.
Huh? Forget about the police. I give you the authority to break it. Break on the southern side. They categorically say that there is no construction made on the southern side of the plaintiff. Yes. Let the plaintiff do it.
Yeah, we'll be happy. Agree?
And taking into account the order is passed only for the southern side, not interfering. Order is passed for only south. No, let us see. The order has been passed on where? Therefore, in the light of discussion, is to together from the front side of the building of the petitioner and open up the right of way for free movement of the petitioner through ingress and air, so and so. So, this is the order. Now, the court was not clear as to whether the order should have been made in respect to the southern side. Southern side, he can have a clear entry, no problem, and if necessary, if there is any disturbance, let the police. Then this court directs the police now to do it. Without going for execution. This court now exercises 227 now. You have to enter only from the southern side. No, from this photograph, which you have enclosed, this is from the southern side. This photograph kindly shows that you have entered from the southern side. Now, your question, your problem is that on this side, on the eastern, they have encroached. And as such, you cannot enter from there. No, but your gate is on the southern side. Your gate is on the southern side. See your boundary of Schedule B. It shows NH highway.
And land of Nitu Loko. That is the wife of the plaintiff.
So under such circumstances, page 42, it shows this on the southern side, NH 37. So why can't you enter from there if it is on the southern side? And the ramp which you are saying about, which the gentleman said on the last occasion, is the ramp from that highway to your land. What happened? The problem which happened is this. As I can get you. Your problem is now you from the southern side you made the entry, and entry landed out there on your eastern side, which they have now encroached. But wouldn't that be allowing the suit at the stay by way of a mandatory injunction on the eastern side? That can't be permissible. Your thing is that whatever construction, if they have made out there, that is another aspect of the matter. But what requires is that you have to have an entry. They cannot block this entry. If you see this photograph also, it is on the southern side. Yes, kindly come here. This is the map. Yes. Hmm. So they have occupied this entire area. How much area they have occupied now? That's almost around more than 2 kathas. So at the time, Mr. Sharma, you filed a suit. This was not, there was no uh, entry made by them at that point of time, encroached. So before filing of the suit, only they encroached. Then how did he enter then? So after filing of the suit, he did not. But Mr. Sharma, the problem arises now. Whether they have rightly entered or not, have you asked for recovery or possession of any land?
No, ma'am.
See your plane?
From Schedule E. Page 40 mile.
Hmm? North, it will be land. South, Guwahati University. performed as Schedule B. So you have asked for recovery of first possession.
My lord, that is Schedule D, not
Schedule
D.
D. No, that is the portion he is saying. Schedule D.
No, my lord. Schedule D, how he becomes the right title interest holder of this Schedule D, there is nowhere mentioned in the.
That he says that it is a part of Schedule B.
No,
It is mentioned, 100% mentioned. It will Schedule D will be a part of.
performance are the owners of Schedule D, my lord. As per his word. And in the plain also nowhere it is stated that Schedule D is a part of Schedule B, my lord. Nowhere is stated in the.
Where you are explaining Schedule D,
21, my lord. For the first time, they have said about Schedule D in para number 21, page 38.
yes, where you mentioned that Schedule D is a part of Schedule B.
Nowhere, my lord.
Where? Page 30. Actually, this should have been some portion of Schedule B. Mr. Sharma. No, Mr. Sharma. In paragraph 21, the second line, it should be Schedule B. There's a mistake out there. If it was some portion of Schedule D, because Schedule D is the entire land. Yes. But that is why you have not, this is a mistake. Should have been Schedule, some portion of Schedule B will become Schedule D. But that we have not done it. But anyway, the question is, if your right of entry is now being given by breaking the wall so that you can go from the eastern side, which is now under their encroachment, wouldn't that amount to pre-decreeing the suit? When at that point of time you were not, at the point of time when the suit was filed, you were not in possession of that area. In fact, the area which he has shown by making that thing, I think this is the you can look. This happens to be the Schedule D area. This area which he has carved out by the ink is the Schedule D area. If that be so, when you are asking for recovery of possession, at this stage directing you to entry from that area, wouldn't that be allowing the suit at this stage when the evidence is everything is yet to be given? Yes. Therefore, I'm saying that is the Schedule D area where you are asking for recovery of possession. And that too not making its statements clearly in your plain. That Schedule B, D is a part of the Schedule D. Was the trial court could have granted the mandatory injunction, thereby allowing him to use the Schedule D area, which he claims that it is his part. Wouldn't that be pre-decreeing the suit? And I understood everything, but this gate they have removed. But by the making of that wall and taking over the possession, the problem which arises, Mr. Sharma, is this. The entry now has to be made through Schedule D. But isn't that a amount of this order is would be pre-decreeing the suit? You have a difficulty there. The problem arises there only. How do I give you a right of way unless it is being declared that he is wrong? But his possession was maybe violated no, he has made that okay. No, Mr. Sharma, all is understood. He have violated the order of 610, not to raise any construction. Understood. Everything is understood. But the fact is, if you ask to go now, which he had taken over possession, you could not have gone after 22-8, because that is the area by which you have to enter where he had already taken over possession. Isn't that your admitted case? So under such circumstances, your right to weigh cannot be there as on after 22-8. Absolutely. But can there be a delivery of possession prior to the decree? How? What is the basis on which the court will give you when it is not even pleaded by you that till now let me use it? Is it your case? No, is it your case that you should be given a right to wait through that? Is it your case anyway? Right to wait from where? You say because of the wall being constructed, but the learned trial court failed to take into account that if the wall is broken, it ends into Schedule D area, which is in his possession, and he admittedly admits that it is in his possession, rightly or wrong. That's a different aspect. It's a very sad thing, Mr. Sharma. I really appreciate what has happened is wrong. But could this order have been passed without taking that aspect of the matter? Problem arises there. Problem arises there, Mr. Sharma. No, the court will grant the relief. But the question is, the learned trial court did not take into consideration that breaking the wall will enter the person to Schedule D land. Did the court take into consideration that? No.
And on the same
Neither
fact,
he argued also.
violation application is also pending on the same fact.
No, it's okay. But the Schedule D area, that is the main point. And if you go there, the problem arises. Anyways, I'll do one thing. I'll have it on I'll stay this order. Because this cannot happen like this, because he did not consider that aspect of the matter. We'll have it on some other day when.
No, my lord. Monday, next Wednesday, my lord.
29th, Wednesday. The appeal is heard Mr. B. Bora, the learned counsel appearing on behalf of the appellant. Huh?
Thirty-first, 30.
30? Thursday. What about the second appeal? Somebody, these people are waiting. Huh? I'm also having now another aspect. Second appeal for senior citizens will be another grouping. So something for senior citizens matters needs to be done early. I would not transgress upon the idea of these second appeal. Let it be there. I'll have it on 31st, don't worry. Or 30th, 29th or 31st. No events will fall. It will happen. But the problem arises there. You may come up with a solution how to tackle it. Now, I am in favor of giving you. Yes, he may have to spend some money on that or do whatever maybe he may have to do. But the problem arises is entering into the Schedule D. Yeah. Heard Mr. B. Bora, the learned counsel appearing on behalf of the appellant, and Mr. H. Sharma, the learned counsel appearing on behalf of the respondent. Mrs. D. D. Borman, the learned additional senior government advocate, had also appeared before this court. And pursuant to the order passed by this court on 17/5/2024, in IA number
141.
Oh, no, yeah. In IA number 1421/2024, the learned additional senior government advocate have placed before this court a set of documents a set of instructions which have been issued by the Deputy Commissioner of Police Crime, Guwahati. The said set of documents, from a perusal of the said set of documents, it transpires that the reasons have been assigned as to why the order passed by the learned trial court on 29/4/2024 have not yet been complied with. The said copy is kept on record and marked with the letter X. The appeal is admitted. Taking into account all the parties are duly represented, this court fixes the matter again on 31st of May. This is an application. This is an application under Order 41, Rule 5 of the Code of Civil Procedure 1908, seeking stay of the order dated 29/4/2024, 6/4/2024, as well as 29/4. As well as 29/4 you are asking?
No, my lord.
Why?
Because after filing this appeal, that was
Okay.
subsequent note.
Yeah. 6/4/2024. Passed by the learned court of the civil judge, senior division number 1, Kamrup Metro at Guwahati, in Mizze case number 1052/2023, arising out of title suit number 619/2023. The learned counsel for the applicant, Mr. B. Bora, submits that pursuant to the order passed by this court on 6/4/2024, pursuant to the order, another order has been passed. Why you are not asking? You have enclosed that order. You are not asking.
My lord, here all the orders were subsequent that we have put.
Submitted that there is another order being passed on 29/4/2024, wherein there is a direction to execute the order dated 6/4/2024. This court, upon hearing the parties and taking into account that the matter is again taken up on 31st of May 2024, finds it appropriate that pending disposal of that till the next date, the order dated 6/4/2024 as well as 29/4/2024 passed by the learned court of the civil judge, senior division number 1 in Mize case number 105952/2023, as well as Mize case number 383/2024, we state the said stay order has been granted, taking into account that the learned that from the perusal of the order dated 29/4/2024, it seems that the learned trial court, while passing those directions, failed to take into account that while entering that the mandatory injunction, if so granted, so directed, would amount to permitting the plaintiff to enter into the Schedule D land, which would amount to partly decreeing the suit even before the trial had started. The same is a prima facie view and shall be subject to further orders depending upon the hearing of the counsels on the next date. এই ফটোখন delete. নাই, নাই। You will require a lot of amendments in your plane. Because that paragraph 21 is okay. I think D should be made B. If you don't make it B, your entire D goes. Huh? And you are asking for, this is the case where you are asking for confirmation, na? Maybe urgency was there. Find out a way, how can it be done? I think he may, because any order passed out there would be pre-decreeing the suit. That is the big problem. Now, there is one judgment of 2004. No, but understood. But would it be necessary? Wouldn't that be an order was of 610 saying no construction? Any construction made by them may be illegal. That is a different thing. But for passing an order, the court said for the purpose of ingress and egress. Can you give an ingress and egress to him, taking into account that that is a schedule? That is the main problem. Yeah. Yeah. That is the problem. Yes.
My lord, I have been instructed to withdraw this.
Withdraw?
Yes.
Oh, that one? Oh, no, this is a new one.
This is different.
Mr. A. Sattar, this is an appeal filed under Section 100 of the Code of Civil Procedure 1908, challenging the order dated, the judgment and decree dated 30/6/2022, passed in title appeal number 7 of the 2010. The learned counsel, Mr. A. Chatta, submits that he has been instructed by the appellant to withdraw the instant appeal. Taking into account the above, the instant appeal stands dismissed on withdrawal. I can't close in view of the withdrawal.
11.
Yes, madam. What is it? Second appeal.
Lordship, my the court
Hello? At the request of the counsel for the appellant magistrate. Yes, madam. Ready?
is a lordship.
Yes, what is the substantial question of law?
Lordship, the learned appellate court, they have wrongly decided the matter by dismissing the trial court's order.
Hmm?
By dismissing the title to your lordship,
Hmm.
which the plaintiff, they have not pleaded the circle officer's order, your lordship. That is not there in the pleading, your lordship. That is the main irregularity, your lordship. Nowhere they have mentioned.
Yes, what is it? Substantial question of. If I remember clearly, on the last occasion, what happened? The plaintiff got a patta.
Yes.
On the basis of the patta, he wanted a notice was issued to him for cancellation.
Yes.
He filed a suit without challenging the notice, asking for declaration of his right title interest and confirmation of possession.
Yes.
The suit was dismissed. The first appellate court decreed the suit without considering anything else, only on the ground that Rule 26
Yes.
only permits the commissioner to cancel subject to following the provisions of law,
Yes.
provision in accordance with the rule,
Yes.
but no power is given to the settlement officer. So the question of law which would be is as to whether the learned first appellate court was justified in decreeing the suit, thereby declaring the right title interest of the plaintiff solely on the basis that a notice that the settlement officer, in terms with Rule 26 of the Assam Land and Revenue Regulation 1886, could not have cancelled the. Isn't that? That is your argument, isn't it? Mr. K. Fukan, the learned additional senior
Junior government.
junior government advocate appearing on behalf of the appellant. Mr. A. Sattar appears on behalf of the respondent. The instant appeal is directed against the judgment and decree dated 28/10/2021 passed by the learned district judge Bongaigaon entitled Appeal number 3/2015, whereby the judgment and decree dated 21/8/2015 passed by the learned trial court, the learned civil judge Bongaigaon entitled suit number 10/2008 was dismissed, was reversed. So the instant appeal is admitted by formulating the following substantial question of law: whether the learned first appellate court was justified in decreeing the suit in favor of plaintiff, thereby declaring that the plaintiff has right title and interest along with possession over the suit land solely on the basis that the settlement officer would not have cancelled the patta in terms with Rule 26 of the Assam of the settlement rules framed under the Assam Land and Revenue Regulation 1886. Taking into account that the respondent is duly represented, no further notice is required to be issued. The registry shall call for the LCR and list the matter for hearing immediately.
Obliged.
IA for what?
Our IA
What is there for the IA? He has got his right title and interest. You can't cancel it. What is this IA? The learned counsel appearing on behalf of the applicant submits that for the present she is not pressing the instant application. However, seeks the liberty if so necessary at the later stage. Taking into account the above, the IA stands closed on withdrawal. However, liberty is given if necessary. Yes. Transfer. Where to where?
Not from Dibrugarh to Principal Judge Guwahati.
Huh?
From the Court of Honorable Additional District Judge Dibrugarh to the Court of Honorable Principal Judge number 1.
Guwahati. Why?
My lord, the parties had entered into the marriage in the year 2012. There
Where?
was some in Guwahati. Then after the marriage, the party resided at Dibrugarh.
Hmm.
And the dispute between the parties started in the year 2018. And in 2018, my party was in Dibrugarh. Even on the day of filing of the divorce application, my party resided at Dibrugarh. But subsequently, some dispute arises which led to a filing of a 125 proceeding. And 125 proceeding, please to come to page 34, annexure 4.
But service, what has happened upon the service?
Service is complete. The other side appeared.
Then their name has been shown.
Yes.
Then
Today
yes,
I called them.
argue.
So,
Other side don't appear, that is their loss.
so, my lord, by judgment and order dated 11/12/2020,
That is not relevant. Relevant is what is your difficulty.
a difficulty your lordship arises from this because the maintenance was granted by the learned trial.
Where?
The maintenance was granted under section 125 proceeding, a sum of rupees 10,000. Now, the respondent concerned has paid me maintenance till March 2021. At that time, as I submitted earlier, on the day of institution of the divorce application, I was residing in his home. But since he failed to maintain me, and presently he is posted in Jammu Kashmir because he is the army personnel, and there was no one there. So ultimately, I have to left my matrimonial because he does not bear my expense.
No, but do you know the problem which will be if I put it out here in Guwahati?
No, Your Lordship, I understand the convenience part because
He has to come.
Yes, yes.
If this, let it be done through the lawyers.
That I agree.
Because otherwise, I would have understood otherwise.
Yes.
But if I put it in the family court, otherwise it's very good. But the problem arises in these type of situations. Every time he has to appear before the court.
My lord.
How do I do it? You tell me.
No, my lord is right. But just I want to submit for your lordship, as per the order passed by the learned in 125 proceeding, the maintenance has not been paid since March 2021. So I am financially completely incapable.
You can very well file an application. See, you can very well file an application before that.
Yes.
Asking that you have not paid and as such get it executed, get it from its salary. You can very well do it. What is the big deal?
Difficulty is only, my lord, I understand that the forum convenience presently the lawyers can represent here. Parties need not appear. That I completely. The only issue is with regard to financial constraint. If this one could take into consideration that aspect of the matter and dispose of the because my maintenance is due since March 2020. It's 38 months. I have not been paid a single cent. And the party is destitute to such an extent that she is unable
What do you do?
to file.
What do you do?
Nothing. She is residing with her father.
Then how are you surviving for 38 months?
Dependent upon her father. Her father is married. Her father is a retired person.
And what is your qualifications?
Qualification I have not asked, but
You should.
my lord, considering the maintenance which has been granted, that this order was passed after considering all these issues, and accordingly 10,000 per month was page 43. My lord, is the operative part of the order. So I can humbly pray, my lord, since in view of the forum convenience, which I fairly submit will be the concerned district judge, because the lawyers can represent. But I need the support, financial support. So that may be considered by. And presently he is married again. He has settled with another kid.
Where is the respondent? What you are asking is with the respondent being present, it would have been better. Is it stay?
Yes, yes.
We do one thing. We keep this stay remaining. You in the meantime file application for enforcement of wanted. That is, I'm not going to file it. Let us see what happens.
All right.
Let this matter be kept in a bit. Heard Mr. A.K. Wright, the learned counsel appearing on behalf of the petition. However, none has appeared on behalf of the respondent, in spite of the fact that their names have been duly shown. It is also seen that there has been no affidavit filed.
Not filed.
No affidavit has been filed, in spite of the fact that the respondent had put in the appearance to the council on 11/9/2020. Mr. A.K. Wright, the learned counsel, further submitted that the petitioner has no source of income, and for her to appear before the courts at Dibrugarh would be very difficult on account of financial constraints. He further submitted that there is an order being passed in a proceedings under 125 directing the respondent to pay an amount of rupees 10,000 per month as maintenance. However, no such amount has been paid for the last 38 months, for which the petitioner's survivors have also become very difficult. Taking into account the above, and as the respondent is not present, this court adjourns the matter to be listed again on 6th of September 2024. In time order passed, the shall continue.
Lord, I am sorry that item 11, my lord. I was in court of.
I gave you a good thing. I'm taking it after 2 weeks or something when I am not here. You'll get your appeal admitted very easily.
It was adjusted in the betterment. It may be taken at PM.
No. You'll have it next week. What is there? What is the urgency?
Urgency means, my lord, there are concurrent finding unless I get some order, and at least admission of the RSA, then they may file.
But you have, but the chance is more for a dismissal, which you would
I
not
hope,
get in other court.
I hope my case would not be dismissed because
Well,
I have some merit.
Let's take it. But then don't go back later on. Huh? Once I take up the matter, you can't go back.
And
I'm giving you that.
I hope I will finish
Chalo.
that point.
Else it will go. Yes, what is your
Other day, my
substantive?
lord, your lordship regarding the first substantial question of law, that is page 11, your lordship desired that whether you have made this statement in WS or not.
Huh?
Now, my lord, we have some citations, that is our High Court as well as our Supreme Court.
Page,
That is
page 11 where?
page 11 of the RS.
Even you can give three of it. Yeah.
That is the number one substantial question of law.
Yes,
So,
was justified in holding that the plaintiffs have been able to prove that they are legal heirs of the daughters of Abdullah Ali. How is this a substantial question of law?
my lord, the personally purchased property has been also made the subject of partition.
Huh?
We purchased the land through register settlement number 609. It is duly exhibited. And that land has been also made subject of the partition. So that cannot be done.
You purchased from whom?
I purchased from one Saptara Begum.
Who is that Saptara Begum?
Saptara Begum is totally a third lady. A third lady, that is Saptara Begum has no connection with either of the parties. So we have purchased this land from Saptara Begum by register settlement number 609. So that land has been also made subject of the suit. And also has been made subject matter of partition. That cannot be done. And second, Lordship, my lord, this Abdul Mia
This land is what? This land is where?
land
The
is
609, which is the plot of land?
yes,
But
plot
he is
of
asking for partition of plaintiff therefore seeks for a declaration that the plaintiff and the performer defense number 4 to 19 are entitled to up to the extent of 3/5 share of the suit property as described in the schedule below as Morasti right. What is this Morasti right?
this, my lord. Whereas as I think it will be Esmali property.
Huh?
Esmali.
Esmaili. Okay. This is filed where?
It is filed by lord Karimganj.
So they use
Yes.
the word Morasti is
Yes,
Esmaili. Okay.
that is there. So that is one substantial question, Lola, how the purchase land of a party can be made subject to
No,
partition.
no, that's under Pargona, so and so, survey, so and so, so and so. Okay, now show me in your defender that this plot of land has been purchased by you say.
Yes, my lord, that is, it is duly exhibited.
No, no, no. In your written state, that this plot of land you have purchased it by 609.
Kindly see page 39. That the part of land of described in the schedule of this written statement was the land of Abdul Ali, grandfather, the principal defendants, and part of the same are the purchased property of Abbasuddin, father of the principal defendant number 1, 2, and 3. So here, who are the appellants? They are the descendants of these three persons.
Now, how does the trial court look into it?
Trial court, he will little, that may be seen, my lord. Regarding
You
that
have
is-
filed an additional written statement.
yes, additional statement is also there. So that has been also annexed. So here, Lordship would see issue number 5. That is page 75 bottom. Here, my lord, the deed has been exhibited by the present appellant's defendant. That is page 82.
No, this deed of partition agreement is in whose favor? Yours.
No, that means that the land which they have claimed is our land.
Hmm.
After social amicable settlement,
Hmm.
this land was in your possession in the year 1977. But they filed the case in the year 2005 only. And that too not by all the legal aid. So that's why the unnecessary parties were not met. That is second aspect of the case. Third aspect of the case is this.
No, let us first be satisfied with the first aspect of the case.
The first aspect must have seen that there is
No, Mr. Mr. Mahmood, this court does not formulate questions of law just for the sake of it. I formulate once, you see, the aspect one has to understand. When you formulate a question of law, the court who is hearing can only say that it is not involved. This court cannot later on say that this is not a substantial question of law. Kindly appreciate that. There
Then
is
what
a
is
difference.
substantial question of
Yes,
law? That is the main question here.
yes.
Here, what substantial questions of law is this:
Hmm.
if something is illegally interpreted, and wrong reading and misreading also a substantial question of law. And thirdly, which has not been discussed in a proper manner. Because my land is there, I have raised.
Kindly come to page 80. Defendant side argued that by sale deed number so and so defendant along with so and so purchase
Is it? Yes.
the land in the schedule and as such the plaintiff had no right. But from a bare perusal of the same, it cannot be ascertained as to whether the land of deed number EF falls within the schedule of the page. It has not been proved as to whether the land of deed number 609 falls within the land covered by dark number so and so, so and so, so and so. Then
No, my lord, that was my lord. Only discussion is there. That discussion must be in accordance with law. That is why I will satisfy your lordship on that point.
so therefore, here the trial court holds that 609 deed does not show that this deed has any relevance to the dark numbers, the scheduled land. This is what is being found. This is a finding of fact.
No, finding a fact. But finding of fact, there is a dark number in a one dark or one patta, there may be many lands. So, and due to passage of time, my lord, the boundary of the land may be also changed. So all these things were not at all discussed.
No. Whether it was discussed, did you say that the number has changed?
No, that is,
Then,
no, that
because this court can't reappreciate the evidence. It is a finding of fact.
no,
Let's see.
finding of fact, it does not mean that finding should be on the basis of conjecture or surmise. It must be in accordance with
Mr.
law.
Mahmood, kindly show me the deed which shows that this scheduled land is there. Is it there? Then I'll say that yes, it is a perversity.
It is in our WS, we have said.
No, in that deed. Because whenever you refer to a deed, the deed has to categorically mention that deed. It has to be proved by way of the documentary evidence, not by way of oral.
All this may be in the record or LCR document.
No. Huh?
LCR.
LCR? Without admitting the, how can I call for LCR?
That's why, my lord. That's my lord.
Sorry.
There is a good questions of law, my lord.
No.
And those points were not elaborated
No.
properly. I do not say it was discussed. It was discussed, but not in accordance with law. Interpretation must not be pedantic, narrow, which may frustrate the cause of justice. So many citations of the Supreme Court is there.
Then better off go to Supreme Court. This court is not satisfied.
No, my lord.
Yeah.
We are poor men. We have no.
Then you
No,
have to be.
I am telling
That is
about
why, Mr. Mahmood, I said it at the first place. You have taken the risk. Now we are I'm not satisfied with one. Question one is not satisfied. Now come to second two. Now you still have the time. We are at 1 o'clock to get the matter adjourned today. You don't have a case. Question number one is not there. Because that's a finding of fact arrived at unless you show. Yes, the deed contained these dark numbers which were a part of the schedule. Or you show that these deed contains these dark numbers and there were evidence also to show that these dark numbers became these dark numbers which now becomes a part of the schedule land. Show me that. If you don't show me that, how is the question of perversity is there?
time of admission, the court may not be so much rigid.
What?
the time of admission,
Absolutely, one has to be rigid.
at the time of hearing, so many things.
This is not a first appeal, Mr. Mahmood. This is not a first appeal. It is an appeal by which this court has to formulate a question of law. And once it is formulated as a substantial question of law, then the court who is going to rule later on will come up and say
Let me prepare a better manner to sit here.
better.
Your lordship is of that. So
I am very
it
strict.
is my duty.
I
to
am very
satisfy.
strict on this because tomorrow, because now what is happening, Mr. Sir, with due respect to my senior colleagues who were there, the second appeals have been admitted in such a manner without thinking as to whether these were at all a substantial question of law. And because of that, in many cases, the people are suffering. This is this is a stage where this court only has to see whether there is a substantial question of. And if it is there, then you admit it. Otherwise, you don't, because otherwise everything is to be done in the first appellate court itself. If there is a perversity, obviously this court will look into it. But you have to show that. And if we don't do it, then people will lose faith in the civil litigation, which is happening. People are losing. You can't help it. Filing after case, because this case, this is a case where if you admit it today, I'm telling you, and I am not strict, I'm telling you this matter would not finish by 2040. The reason is very specific. It won't finish because many people out here, there are so many defendants, many of the people will die during the pandemic.
Will come in field.
Yeah.
I understand that.
And one has to very strict. Okay. At the request of Mr. M.U. Mahmood, the learned counsel appearing on behalf of the appellant, matter be listed again on 12th of June. I am not there. Mr. Mahmood,
My lord.
you said on that day that you are withdrawing the appeal testament paper.
IA. We have prayed for IA. Withdrawal of the IA with liberty to file a fresh IA to substitute the legal heirs of late Dullah Chandra Singh. The number is IA is there, but order is passed in testamentary appeal. Only that appeal may be restored, and then we will file this because we have filed another IA, but due to disposal of the testamentary appeal, that is not accepted by registry.
Today is 24th, na? It will be on 17th. It was item 1.
Order was passed on 17th.
Good. IA. You have filed an IA?
Yes, newly I have filed, but that is not accepted.
Huh?
That is not accepted by registry because testamentary appeal has been shown as disclosed. So in a disclosure petition, they are not accepting. So now your lordship may kindly restore the testamentary appeal, then this IA will
No,
go.
how can I restore it unless you file an IA?
So that I mentioned, but your lordship said it is court mistake. So
No, understood. That is why I say. I thought that you filed an IA.
no, I have already filed. I have already filed. It is filed on. IA has been filed for substitution.
No. IA for correction. Why haven't you filed
That
that?
is not filed.
No, without that, it is not possible. I cannot correct it unless you file an IA for correction of this order. No?
Then lordship may kindly fix on Tuesday next, and the meanwhile I will file.
Hmm?
This petition. Jurisdiction extraordinary power by that view.
No extraordinary,
Kumamoto can also take up the matter.
no extraordinary power.
I will file. Let's be on Tuesday. Monday I will file and mention.
To Pelekippa. Not document. It has been brought to the attention of this court that on 17/5/2024, the appeal was fixed for the purpose of withdrawal of the interlocutory application being IA number 930/2024. However, this court had passed an order for withdrawal of the testamentary appeal number 3/2017. The learned counsel appearing on behalf of the appellant, Mr. M.U. Mahmood, submits that he is going to file an application for necessary correction to the order dated 17/5/2024. An application for recalling of the order dated 17/5/2024. So, taking into account the above, list the matter on 29th of May 2024. So, in the meantime, the application be filed. You file it by Monday.
Yes. 35 rupees. Morning I have that may kindly be written so that I may file it.
Huh?
Morning we have sent the
Hey.
file of that.
This is an application file. Who is appearing for the state? For correction of the order dated 23/2024, whereby this court
Affirmative.
directed the appellants in the accompanying appeal to deposit an amount of rupees 39,38,205 before the registry of this court on or before 25/2024. It was also mentioned in the said order that liberty was granted to the appellants to file appropriate application before the registry of this court for release of the said amount. The learned counsel appearing on behalf of the applicants in the present interlocutory application submits that the word ought to have been respondents in paragraph number 6 of the said order dated 23/2024. This court, upon perusing the order, is of the opinion that there was an inadvertent typographical error in recording in erroneously recording the order, erroneously stating that the liberty to be was given to the appellant, which ought to have been the liberty to the respondent. Respondent or respondents?
Respond.
Respond. Accordingly, this court modifies the paragraph number 6 in the order dated to the order dated 33/2024. 33/2024 or 23/2024, thereby granting the liberty to the respondents to the appeal. Respondents of IA Civil 1547/2024 to file appropriate application before the registry of this court for release of the said amount. The registry may permit such release of the amount subject to furnishing an indemnity bond and after due verification. The instant order shall be a part of the order dated 23/2024.
Sir,
With the above, the IA stands disposed.
same mistake is done in the RFA 56 also.
Huh?
Annexure 1.
What has happened?
Same mistake. In the Annexure 1 also, in the RFA 56, in the main case, same order has been passed.
RFA 56?
Yes.
Which order?
Annexure 1, Annexure 2.
Where?
Page 13.
1-3?
Yes.
What happened? What mistake?
In para 6.
That is the para 6 order. That is the order actually should have been passed in the IA.
IA, yes.
They have, you got a, you, this is, you see, this page which you have got, they have given you a wrong certified copy. RFA, that is not the order. RFA order is different. RFA order is heard Mr. Tina, the learned senior government advocate, appearing on behalf of the appellants, and Mr. S. Sahai appearing on behalf of the respondent. There is only one respondent.
Yes.
Why you are saying respondent?
No, only one.
Respondent. Appeal is admitted, call for the records, this is the matter for hearing. So there is no mistake in RFA.
File it.
Yes, Mr. That day, yes, you, Mr. H. Purawan. That day, you remember that matter testamentary appeal? It was withdrawn by Mr. Mahmood. It was actually not the testamentary appeal, it is the application which was withdrawn. Anyways, he today, we have it as unlisted today, but anyways, I didn't pass an order. I've asked him to file an IA for correction. So we'll again take it up on 29th. Okay?
In the instant case, Your Lordship, item 12,
Hmm.
the respondent had expired, Your Lordship. I think given some time to obtain instruction, file necessary application.
When did the respondent expire?
He came to know only, Your Lordship, a few days back, Your Lordship. Date has not been ascertained.
When?
The respondent is the executor of the will.
Hmm?
The respondent is the executor of the will. There are two executors.
Appeal against what?
Your Lordship, against the probate.
Whole respondent expired.
Sole respondent. But after going to the will, Your Lordship, I found that there are two executors.
Hmm?
There are two executors named in the will, Your Lordship. But if we allow obtain instruction, Your Lordship, whether the other executor is there or not.
Now, there was a stay.
There was a stay in that regard, Your Lordship.
IA. There's no IA.
No, I,
So if there's no stay, then what remains? Has this not yet been put into execution?
not
The
yet.
probate. Probate was given in 2012.
Lord.
Then
Thereafter, Your Lordship, there is no communication with the client, but we are directed to take fresh steps after ascertaining the correct place. And as and when we have contacted, Your Lordship, they have informed that the respondent has died.
but if the will has already been probated, then and against whom you have filed?
There was the executor.
Executant. Executant is also the beneficiary.
No, Lord, it is the issue, Your Lordship, at the time of filing the probate case, the beneficiary was not made party.
But what happens? The beneficiary, if it is not a beneficiary, can this appeal be maintained at all?
The beneficiary is not made a party, Your Lordship, but the appeal also only the executor was made a party.
Then how can this appeal remain?
I will discuss on Monday, Your Lordship, the time has obtained.
Because the
instruction from
executant cannot be made a
the
party.
In the main probate case also, the beneficiary was not a made party. Like,
No, he can very well. That's a different thing. Filing a probate is just a legal recognition. Who has to be made a party is actually the person who may be affected,
beneficiary.
who may be otherwise affected.
They can get a party.
Just for others, you may be the person who may have been affected. But if the beneficiary is not a party out here, executant too, he has done it. He has already got the executed. Now it becomes it has been legally recognized. Then what to do?
On Monday, Your Lordship, at the opening instruction, I withdraw.
Mr. H. Gurangwai, Learned Counsel appearing on behalf of the appellant submits that he may be permitted to obtain certain instructions in the matter as to whether the instant appeals would survive without the beneficiary being made parties. Could list the matter again on 29th of May.
Keep the obligation. So what can be my senior teacher was the
Wait, nothing is there. Wait, tell me, what steps
Document.
undertaken by the upon response not yet received by the section in view of the matter we play. Yes, why haven't you taken steps? Huh? What is this I for? Why haven't you taken steps? Two 2020, Mr. P.K. Roy Chaudhary, the learned counsel appearing for the petitioner, submits that due because of oversight of the counsel on record, the steps required could not be taken. Accordingly, prays for 1 week's time to take steps. Then, 4 years down the line, also you have not taken steps.
Because he is coming.
2014 matter. CRP Khanko. What remains in this case? রাখো, dismiss করবো রে। Ask Mr. P.K. Roy Chaudhary to be dismissed. Ask your senior to come.
Yeah.
Yes, I will dismiss it in him, with him.
14.
With cost also. Without you, with you, there was no cost. Hmm. So LCR received.
LCR received it for hearing.
Yeah.
But if possible in the month of August.
Yeah, for service being complete and the LCA having been received, list the matter for hearing in its usual court. Parties are given the liberty to file applications for early hearing.
Case docket, last docket 10-5 docket, the notice upon response number 3 docket answered.
When to take first step?
Whatever actually response number 3 is the wife of response number 1. Response number 1 already appeared. I have taken step 3 times, but it is returned back.
Who is the response number 1?
Yes,
Why? There's a husband-wife fight. Are you staying together?
no, husband wife docket. Response number 1 is the husband and 3 is wife docket. So 3 notice not served.
That is what I'm asking him.
So, yes.
Is there a husband-wife, husband and wife fight? Are they staying together or not? We are in the second appellate stage. What is this CRB for?
Section 6 specific effect. Section 6, under section 6 specific.
You got it in your favor or against you?
To dismiss.
Okay, let me further dismiss it.
Not to tell us.
No. It's 2015 matter. It has
Title,
been dismissed. You should have filed in the meantime a suit. What is this? There are small petty matters and you need to finish up. Only 2 things.
yes, sir.
What is that?
That disposition.
Whether you filed it within 6 months.
Yes.
That's all.
Yes, so here also title was decided.
Issue number
Tell you,
6.
whatever may be, it has been decided. This
Issue
shall
number
not
6.
affect you for filing a suit for time. Matter ends. Where is that? Where is that finding? Not
That
other.
Issue number 6.
Problem happens that the learned trial courts, they decide these suits,
Regarding this
court
position,
theory and all this, whether the plaintiff has right title and interest, is entitled to compensation, whether the suit is bad for non-joinder of parties, whether the plaintiff or not the plaintiff is entitled to restoration. Section 6. The only question to be determined is as to whether a possession within 6 months prior to in the case of plaintiff is paid to prove the case that he was in possession of the suit and fighting the suit, and he was illegally dispossessed with a defendant. He could do it who cultivated the to the so there's nothing wrong. So we dismiss this, however, observing that all other things shall not preclude you from fighting.
not
No. Don't come up with all these things. These are silly matters. You see, I'm not looking into this. I'm only seeing issue number 7. Matter ends there.
issue number 7, Lordship, how it is decided, Lordship, only along with 7. Issue number 6, it was decided.
No, 6, forget about that.
Yes.
We are not concerned. 7.
Court decided 6 and 7.
Only thing which was entirely required in the entire judgment is this, issue number 7.
Issue number 7 is, Lordship,
Nothing
what
else.
relief or delay.
Whatever may be, actually, the entire case should revolve around issue number 7. Those 5-7 lines was enough.
Yes.
There was no other things necessary. It was stated that for the last 1.5 years, the PW 2 and 3 says that the plaintiff did not cultivate it.
But others, Lordship, title.
That is why I'm saying the other observations are not necessary. However, this is there. So under such circumstances, the plaintiff may be entitled to file suit if they feel so in accordance
Yes.
with.
Title part, Lordship.
I remove that. Unless this is an application under 115 of the section 115 of the Code of Civil Procedure 1908, challenging the judgment and order dated 22/7/2015, passed in title suit number 33 of League 2012, whereby the learned court of the Munsif number 2 at North Lakhimpur had dismissed the said suit. It is relevant to take note of that the said suit was filed. The said suit was a suit filed under Section 6 of the Specific Relief Act 1963 for recovery of possession. The only requisite for deciding a suit for specific deciding a suit under Section 6 of the Specific Relief Act 1963 is as to whether the plaintiff had been dispossessed wrongfully without following the due process of law within 6 months from the date of filing of the suit. This court had taken note of the impugned judgment and order, dated 22/7/2015, and from a perusal of the said impugned judgment and order, it reveals that from the evidence, the learned trial court had come to a categorical finding that the plaintiff failed to establish that he was in possession of the suit land within 6 months prior to the filing of the suit. This court, however, takes note of that the learned trial court have also gone into various other issues that is the issue as to whether the plaintiff had right title, interest, and possession over the suit land, whether the defendant number 9 was entitled to get any compensation from the plaintiff for the suit land, which was not at all necessary in a suit so filed under Section 6 of the Specific Relief Act 1963. So this court also observed that there is no perversity in the finding in respect to the issue number 7, which have been held by the learned trial. However, the issue which were decided, being issue number 3, 4, being totally not relevant, the observations so made by the learned trial court in the said issue ought not to has to be therefore disregarded. Accordingly, this court finds no ground to interfere with the findings as regards the issue number 7, for which the instant petition stands dismissed. However, as regards the issue number 3, this court, for the purpose of clarity, makes it clear that the observations were made in respect to issue number 3 and 4 by the learned trial court shall not bar or disentitle the plaintiff to file a suit, regular suit, for recovery of possession, if so entitled.
Apply, sir.
Yes, Mr. P.K. Roy Chaudhary.
The steps were taken on 17. Last date was 19/1/2020 to be taken steps. We have taken steps on 17/2/20. So,
Then, what type of cases?
this is a case, where
In 2011, there is an order being passed whereby the leave was granted to them to file, liberty was given to file a suit. We are in 2024. Then why
Your
should we
Lordship,
interfere?
only thing is this, they made a false statement before the court that they have filed a second suit over there, where we will be allowed to file a written statement and take all our grievances over there. Then we approached the trial court and found there was no second suit filed over there.
Very good. You should be happy.
I will be happy. Only thing is that, Your Lordship, that portion of the order where
I will say that no steps have been taken.
I have taken steps, this is 17/2/2020. 19/1/2020.
17,
17/2/2020 I have taken steps.
then
Last order was 19/1/2020.
21, 2020.
And this is 17/2/2020 we have taken.
Why did you take it by postal talama? You were supposed to take it by registered post. That was the order.
Registered post we have, but we have taken registered post on 2004.
No. You said that when there were steps required to be taken, could not be taken. Accordingly, he prays for 1 week's time to take appropriate step in the matter. So when there was a direction to take steps by way of registered post, you have not taken. That is why it has not gone. Anyway, that is the ground for which I am going to dismiss it, and on merits I am touching it and dismissing.
Only thing Your Lordship will consider that aspect, because that was a blatant lie by them for the Honorable Court, saying that they have filed a second suit. I may be happy, there is nothing, they have not filed a suit. But this will remain in the order that they have filed a civil suit over there, for which I will file a written statement. But because they have withdrawn the earlier suit only because they have not got an injunction. That is why they have withdrawn with the liberty to file a fresh suit. They are not against that order. When we approached this court, they said that we have already filed a second suit. So this Honorable Court directed us that you, because the second suit was filed, go there and file a written statement taking all your grievances.
Where is the order here?
In the main review petition.
Huh?
Main review petition you also will find.
Review?
Review,
CRP.
CRP review.
CRP, why there's a delay has not yet been condoned.
41 days, delay of 41 days.
Has not been condoned. And the court is
Well,
passing orders right, left, and center.
Well, nobody has appeared before them. We have taken twice or thrice. We have taken registered court. Well, your lordship may look into this registered court. They don't appear before this court. This is the
Earlier, somebody appeared, Siladitya, Learning Council appeared for response number 1, informed the court that response 2, 3, and 4 had died.
well, so they have appeared. Well,
Have you filed any application for substitution?
that appeared.
Then 2, 3, and 4 has died. Then matter goes, praise that, submitted that the response number 2, 3, 4 during the pendency of the suit as such praise that he has instructions to pray for striking out the names of the response number 2, 3, 4 from the array as his names are struck off. So 2, 3, 4 is not there.
Not there. Only one is
Only one is there. Then
against that, well, your lordship may just look into that order in the review application, which was filed in the civil litigation petition. That is that page your lordship will find. It is that page, my lord, 148 to 149.
8 to 149.
The review petition.
What review petition?
My lord, against the High Court civil revision order. I was not in the civil revision. Civil revision, my lord, your lordship will find we have filed an application for review. There is a delay in the review application for
There is review here.
review. Man.
Civil revision is not there.
Not there. Man. Civil revision was disposed of.
When?
Well, it was disposed of on 2/6/2013.
Okay, people,
26,
26, 2013. Admittedly, the subsequent has already been filed, which is pending for disposal before the learned court below. In view of the above, it is open to the petitioner to set up a fee as has been set out by the present revision in the written statement as to and so. And if the present has already been filed, such fee is not allowed. Then what happened?
Well, when we approached the trial court, there was an instruction from the information from the RTI, my lord. That is in the review application you will have to find. Last page 152. Man. As per information
MC 1944 is against the review.
My lord. Page 152, you will have to
What review you are
taking? My lord, I got information from the RTI.
No, why are you seeking a review?
Because my lord, when I approached the trial court, there was no suit pending. My lord. They have not filed any suit. On making a first statement before the court, they have got that order of the civil revision. Our civil revision petition was disposed of. That there is a second suit filed, you go and file it. At page 151, you will find 151. Through a public information officer, we got the information from the trial court.
So why do you need it?
But only that observation, my lord, there is a second suit pending. That much, my lord, can explain.
Why?
My lord,
If it is not filed, very good. How does it help? How are you affected?
Affected, my lord, if they file a second, my lord, we can raise the point of a res judicata, because without a liberty, if they have withdrawn the suit, they have now, the point of liberty was given to them, against which we approached this. They appeared before this court and made a statement that we have already filed a second suit. Where we can, the High Court, my lord, Honorable High Court, directed me, you go over there, in the written statement, you file all your objections, what you are raising before this.
No, by review, you want to recall that earlier order.
Only that much of it, my lord, that they have filed a second suit. It is not pending. There is no such suit before that. They have not filed any suit. Their observation in that last order, my lord, you also will find in the civil revision, my lord, it is open to the petitioner to set up a plea as has been put up in the present in the written statement, if not already filed. So we were given a liberty to file a written statement in the second. So there is no suit at all. Why do we file it? That is why we came to this court, to expunge that portion. Civil revision. Because, my lord, to the public information officer.
How are you affected?
Affected, my lord, because this if remains, so that plea of res judicata will not come. So without a liberty, so they have been given a liberty that to withdraw the suit and file a fresh.
Your liberty is already there.
No, they are liberty. They are the plaintiff in the. So they have withdrawn. We have filed a written statement. They have not got a.
What suit did they file?
Right title interest and to stop my construction.
Huh?
And to stop my construction.
You constructed now.
I have constructed this, so they have withdrawn the suit and they have said, my lord, with the liberty to file a fresh. because there was no injunction given.
Then what happened?
So against that liberty order, my lord, we approached the High Court with the civil revision. So they stayed before this court.
Now, right title, nothing has been done.
Nothing has been done, my lord. And they have come before this court and say that we have already filed a second, which was the liberty was given. So this honorable court held, my lord, if they have filed a second suit.
Now, this is an application filed under Section 5 of the Limitation Act for condoning the delay of 41 days in preparing the accompanying review application. This court have duly taken note of that by an order dated 26/6/2014, this court have duly taken note of that by an order dated 26/6/2014, steps were directed to be taken by way of registered post with AD. Thereupon, on 1/9/2014, when the matter came up, the counsel appearing on behalf of the petitioner sought for 7 days' time to take appropriate steps. It is also seen that on 21/2020, again the counsel appearing on behalf of the petitioner sought for time to take steps within 1 week. However, the office note dated 16/5/2024 shows that steps have not been undertaken by the petitioner upon the respondents. Today, when the matter is being taken up, Mr. P.K. Roy Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that steps have been taken by Postal Alabama on 17/2/2020. However, the steps ought to have been taken by way of registered post. And that too within 1 week, as per the order dated 21/2020. The same is not in accordance with the liberty which was granted by this court by the order dated 21/2020. This court have also taken note of this shows that the applicant is not, the petitioner seems to be not interested in the instant proceedings. This court have also taken note of the review application and the reason why the review application was filed 114 days, not 41 days.
Yeah, it was.
From a perusal of the review application, it revealed that the petitioners herein initially assailed an order dated 16/8/2011, passed in title suit number 17/2007 on the ground that the learned trial court ought not to have granted the liberty while allowing the appeal, allowing the withdrawal of the suit. This court, taking into account that the subsequent suit had already been filed, disposed of the said revision application, that is CRP number 402/2011, observing that the petitioners herein, who would be the defendants in the subsequent suit, would be able to take all the pleas available. It has been brought to the attention of this court by Mr. P.K. Roy Chaudhary that the review application has been filed on the ground that on making inquiry, it was found out that there was no suit filed, subsequent suit filed. In the opinion of this court, that the said would not constitute any error apparent on the face of the record or would be a sufficient cause to exercise the review jurisdiction. The said may at best be taken as an intimation to this court that there was no subsequent suit. Taking into account the above fact that the petitioner seemed to be disinterested, this court dismisses the instant application for condonation of delay on the ground of failure to take steps at that. Consequently, the accompanying review petition cannot be entertained as have become part of it. Yes, what is this? What? Yes, what is this? How much delay?
581.
Huh?
581.
581 days. Service?
Served.
Served. Yes, why? So we are don't file the petition. What is your ground?
Paragraph 3, page number
That his wife is a patient of neuropathic. How many people have filed? Petition. Against return of the plaint. How the revision is maintainable? Oh, Mr. Loskar, every day I have to teach you something. Have you seen the CPC? Or you don't have it? Get hold of a CPC. Yes. Order 43. Which are the orders? This is an order passed on the order 7 rule 10. Isn't it appealable? First one, Order 43, Rule 1A. An order under order Rule 10 of Order 7 returning the plain to be presented in the proper court. That, have you seen this or not? Or you have not been able to locate the section also? My goodness. You have not been able to locate.
I'm in order 40.
What?
Order 40.
Not 14, Order 43.
40.
Rule 1A. What does it say? What does it say? Or do you have the CRBC with you? Then?
Order
43, 43.
Rule 1A. 1A.
It will be in the form of XLIII. 1A. What does it say?
1A is not there.
What?
2016, I don't know if they have.
Order 43, Rule 1A is not there?
An order under Lordship. An appeal shall lie from the following orders under the provisions of Section 104, namely, an order under Rule 10 of Order 7, turning a plain to be presented to the proper, except where the procedure specified in Rule 10 of Order 7.
Done? Yeah, petition is not maintained. Hello. This is an application under Section 5 of the Limitation Act for condoning the delay of 581 days in preparing the accompanying civil revision petition, challenging the order dated 5/1/2015 passed in title suit number 260/2012, whereby the plaintiff was returned for presenting the same before the appropriate forum in compliance with the directions of the appellate court of the civil judge Karimganj by order dated 17/6/2014 passed in Miss Appeal number 14/2013. This court had perused the application, and from the perusal, from the perusal thereof, it is seen that on the ground of the wife of the applicant was suffering from neuropathic breakdown, it was stated that the applicant could not file the appeal within the period of limitation. It is seen that the appeal was filed along with the instant application on 25/11/2016. The order which was passed was on the order which had been impugned is an order dated 5/1/2015, passed in title suit number 260/2012, whereby the plaint was returned. This court have also perused the medical certificate which categorically shows, which is of the date 2/5/2016, stating inter alia that the wife of the applicant could very well join her duties. There is no explanation whatsoever thereafter as to why, after 5-6 months thereafter, the suit was, the appeal, the application, the appeal was filed, the revision application was filed. Under such circumstances, in the opinion of this court, the delay of 581 days having not been sufficiently explained, the instant application is rejected. Apart from that, this court also finds it relevant to observe that the accompanying revision application is also not maintainable in view of the fact that an appeal lies against an order of returning of the plaint in terms with Order 43, Rule 1A of the Code of Civil Procedure 1908. Taking into account above, the instant application therefore stands dismissed. The consequential effect of the dismissal of the instant application is that the accompanying revision application cannot be entertained, being barred by limitation. What? You have already given the liberty, go and file the suit in the proper forum.
Apply.
Here, party both the matter in the instant batch of issue. For the end of justice, matters then adjourned again on 14th of June 2018. Parties the matters that appropriate of
We have taken it even last paper and two 12.5 days with he has been returned unserved.
1, 2, 3, 4.
One.
You are paying for whom? 5, 6. The service being not complete against the respond number 1 to 4. Petitioner is directed to take, appellant is directed to take fresh steps by way of registered as well as usual within 7.
It is better earlier said by the Honorable Court, my lord, some talk of compromise has been going on. The appellant has written one letter also, has given, but it was not falling in this, my lord, did not received by the exact officer. That's why it has not yet been disposed of. So, my lord, may I pray some 2 weeks or 3 weeks, my lord, time, because this letter was given on
When did you file this application? How much was the delay?
The delay is, my lord, about 2 years something, my lord.
Then?
But, my lord, fact is this, as per section 32, as your lordship has decided in one matter, 31 subsection 5.
It was the ex parte decree.
The ex parte and the copy of the award has not yet been received till today.
Then how did you file 34?
34, we have received the notice from their execution note, my lord, money execution case. We have taken that photocopy of that award, my lord. But in fact, until and unless we receive, my lord, as per your lord has decided in that case, it is not, my lord, proper to file this that petition, my lord, under section 30. That is Mukut Kolita's case, my lord.
Yes, Mr. Sharma. Huh? Page is application and the other. When was the award passed?
It was 24/12/2020, 2013, my lord. 2013.
Parte.
Yes, 13. But this, my lord, postal receipt, it appears that, my lord, the pin code 781023, but he is in Belkala area 028, the wrong address. It appears, my lord, on 24/2/2014, the pin code appears that, my lord, 781023, but his address is, my lord, this is
Award was passed in 2013
Yes, yes,
and these postal receipts are of 2014. Why?
14. After that. After it.
Hmm?
April.
Yes, why? If it is of 2013, why it has been given so delayed? And who has sent this?
Yes. Normally we have received it from their money execution case. We have nothing.
Did you enclose this in your money?
Yes, money execution case. This is not our case.
No, did you enclose
Document.
anything? Of
Yes,
it?
yes. In their document.
But the trial court, the first appellate court did not consider this aspect of the matter. When he says two things, he says two things. First, there's gone expertise. I have not received a copy of the report. Now, therefore, the question is that the learned first appellate, the 34 court ought to have taken into consideration as to whether it was served or not. There's nothing mentioned in the order.
My lord, for prayer of the copy of the award, he has written two letters at page 84 and 89 to the my lord arbitrator. But till today, he has not received.
He has to file because something has to be explained.
Yes, yes.
We set aside this thing. Because you see, these unnecessary, let his 34 be dismissed on merits.
Yes.
We set aside this.
Hmm.
However, granting you the liberty to, we set aside this only on the ground that the court did not look into it. They'll have a fresh look, and you may very well produce necessary document. This is an application. This is 37 appeal.
Yes. It's a third. Without receiving the award, my lord.
This is an appeal filed against an order dated 19/5/2018 passed by the learned Additional District Judge number 2, Kamrup Metro at Guwahati in Miss Case number 49 of 2016, whereby the application seeking condonation of delay was rejected. Although the appeal has been filed in terms with Order 43, Rule 1R, 1D of the Code of Civil Procedure 1908, but taking into account that this appeal ought to have been filed under Section 37 of the Arbitration and Conciliation Act 1996, this court converts this appeal into an appeal under Section 37 of the said Act 1996. It is seen from the impugn order that it is seen from the application which was filed for condonation of delay that the applicant, that the appellant herein categorically stated that the appellant have not yet received the copy of the original award. It was further mentioned that on 12/9/2015 and lastly on 3/8/2016, the appellant have sought for the certified copy of the arbitration award dated 24/12/2013 in arbitration case number 493 of 2013. However, the arbitrator have not furnished the same. it is no longer res intriga that an appeal has to be filed under an application under Section 34 of the Arbitration and Conciliation Act 1996 has to be filed within 3 months from the date the award is served, is delivered to the party, to the aggrieved party. This court also finds it relevant to take note of Section 31(7), 31(7), 31(5), as well as Section 32, 32 na? Which stipulates that the arbitration proceeding shall only terminate when the award is delivered to the parties. This court further takes note of the submission of Mr. M. Sharma that the award was duly delivered to the appellant in accordance with, in terms with Section 3 of the Arbitration of the Act of 1996. Be it as it may, one aspect of the matter is very clear, that unless and until the award is delivered in accordance with the provisions of the Act of 1996, that the proceedings, arbitration proceedings does not terminate. Under such circumstances, this court, these aspects of the matter, however, seems to be not taken into consideration by the learned court of the additional district judge, Kamrup Metro at Guwahati, while passing the impugned order dated 19/5/2018. Accordingly, the instant application therefore appeal stands allowed, thereby setting aside the order dated 19/5/2018 and thereby directing the learned additional district judge number 2, Kamrup Metro at Guwahati to again to decide afresh the application under 34(2) (3) of the Act of 1996 as to whether the same is within the period of limitation. The respondent herein shall be at liberty to produce all such documents as so advised to prove that the award have been duly served upon the appellant. With above, the instant petition stands disposed. So taking into account that the parties are duly represented, let the parties are directed to appear before the learned court below on 17/7/2015.
77. Apply.
22. Service being not complete, the petitioner is directed to take fresh steps upon the respondent by usual as well as by registered. It is further observed that the petitioner shall take proper steps in the proper address, taking into account the office note which stipulate that the service could not be meted out on account of insufficient evidence. The same shall be done within 70.
33.
This as a structure, all respondent of the expert.
Mr. D. Kulchal, the learned counsel appearing on behalf of the petitioner submits that taking into account that the respondent had already expired, the instant proceedings have become infructuous. Accordingly, the instant petition stands closed as it had come instructed.
Publish.
Yes, what is this matter?
Lordship, the name of the pro forma may be struck off because we are unable to trace out the
No, it's
alternate.
continue. Yes, what is this case about?
The case, Your Lordship, is an application was filed by the respondent for probate, taking probate of an
Which is the order? The Learned Counsel, this is a page 62.
the impugned order, Your Lordship, it get it page 62, Your Lordship.
Yes, what is it? You are
No.
the petitioner.
No, I'm the petitioner.
Here you are the petitioner. There,
There I'm the respondent number 2 and 3.
what proceedings is this?
But no,
What proceedings is this?
this is a probate application they have filed.
LA.
LA means they have under 2 sections they have filed 276 and 290 for letter of administration as well as probate on the basis of the will of the deceased father-in-law of the petitioner before Your Lordship. Now, I am the wife and son. I'm representing the wife and son of the youngest son who has expired prior to the demise of the veteran. Now, the elder brother is in possession of the property and who is the beneficiary to the will. The other son who was we have made as the defendant number, respondent number 2. He was the defendant number 1 in the probate. Now, his address, he filed the address, and thereafter, because of the signature, we have disputed the signature. Our application was allowed initially to bring on record.
No, why do you want this paper?
Because the signatures are there of my father-in-law in those.
There is
two
no
papers.
other document.
No other document.
Why?
Because I do not reside in the house. I am I am an Anganwadi worker along with my youngest son, only son, I reside elsewhere.
Whose will it is?
My father-in-law.
And father-in-law didn't have a bank account.
Bank account details we are totally unaware of because the elder brother has restrained me from the entering the suit premises, which is the subject matter of the probate. Means on the basis of the probate, he and my son.
You are asking the NRC process out there to get it out there. That is next to impossible. Now too, you can't get any.
That is the means we do not have any document.
Don't know document. You ask for some handwriting or ask somebody else. You may know your father-in-law would be your sister-in-law.
No,
You are appearing for
there are only.
You are appearing for whom?
I am for the widow of the deceased youngest son.
She has never seen her father-in-law sign.
She has seen, but to substantiate before the trial court, Your Lordship.
What do you need for that handwriting expert?
At least
it is there in 47. The explanation to 47 will come into play.
Because
How
those
do you
two
call for
documents
this?
I have, a photocopy I had with me, which I had because my name was inserted by my father-in-law, a copy was given to me with regard to that your name is being there in the application which he filed before the NRC, being the head of the family. That was sent to me and my,
This deed, this will, probate, why is it so relevant?
because that is the house he is residing, and my
How big is the house?
partner,
How big is the house?
the house is the only asset that he has left.
So why don't you ask, he has some house, obviously he must have had a bank account.
But if your lordship sees the will, means why the will is important, because he, in the will, he made a provision that the elder son would construct a terrace room, and then he will hand it over to my son. But that has never been done.
So that is not a question, you are challenging the will.
I'm challenging the will.
So we are not concerned about that, but asking this document, that is next to impossible to get.
But she does not have any other document to.
So you don't, you have to apply your mind. Well, how do you get the document? Or do you pay you the.
But we had brought on record, which was allowed by the London Trial Court initially. Annexure
We are
50,
not, I'm so
Annexure
not
F.
satisfied with this. The order is okay. Doesn't call for interim.
But your lordship,
These documents, you are not going to find it from NRC, meaning thereby the probate proceedings will be.
no, that is true with regard to that, but this will be in contrary to Annexure F, your lordship, which was allowed after the objection met your.
What is Annexure F?
Annexure F, your lordship, page 58, whereby these two documents which we brought on record was allowed by the Learned Trial Court after
Okay.
hearing the parties thereof.
Okay, that is different. But here you are asking for original document.
Because I have only the photocopies with me.
So prove those photocopies, whatever you.
No, now I can, your lordship, for
Yes, that you are asking your father's, you are paying for the son.
his son, eldest son.
Impossible. That cannot be done. You are your father must have had a bank account. So introduce it.
No, I can, for 506, but 106 can be, he is the best person to disclose, your lordship, under the thing. But I
Regarding
have
what?
to- Interrogatory, I have to use for that purpose.
So you do whatever may be, but this is not done. No. Heard Mr. A because the learned counsel appearing on behalf of the petitioner and Mr. M.K. Sharma appearing on behalf. This is an application under Article 227 of the Constitution challenging the order dated 6/7/2019, passed in LA case number 11/2018, whereby the learned district judge Kamrup Metro at Guwahati had rejected the application for calling for the original copy of the filled up NRC form submitted by to the NRC Seva Kendra dispute by Dilip Sharma.
Yes, sir.
It's not Sri. He's dead.
That late.
By Dilip Sharma, bracket since deceased. This court, upon hearing the learned counsels of the party, is of the opinion that no interference, that is of the opinion that the order dated 6/7, no, in Mr. A. Biswas, the learned counsel appearing on behalf of the petitioner, submits that in order to prove the will, submits that as the petitioners herein have assailed the will, and in order to prove that the signatures appearing in the said will is not the signature of the deceased Dilip Sharma, the petitioners have called for the original copy of the form filled up of the NRC form submitted by the deceased Dilip Sharma. On the other hand, Mr. M.K. Sharma, the learned counsel appearing on behalf of the respondent number 1, submitted that a perusal of the said application so filed would show that they wanted the original form only for the purpose of obtaining a certified copy. And for that, the question of calling for the said document does not arise. So, this court, upon hearing the party, upon hearing the parties have inquired with Mr. M.K. Sharma, the learned counsel appearing on behalf of the respondent number 1 as to whether late Dilip Sharma had any bank account. He submits that late Dilip Sharma had bank accounts in his name. Taking into account the above, this court is of the opinion that no interference is required to the order dated 6/7/2019 passed in LA case number 11/2018. Inasmuch as this court finds no infirmity for exercising the jurisdiction under Article 2 to 7 of the Constitution. Accordingly, the instant petition therefore stands dismissed. The interim order passed on
It was passed at
18/9/2019 stands vacated. And as the parties are duly represented, they are directed to appear before the learned trial court, before the court of the District Judge Kamrup Petro at Guwahati on 19th of June 2020.
obliged.
So you got it?
Yes.
What is required? And if I... Yes, what is this? IFI?
Containing 7 days delay.
Yes.
What
Mr.
happened
Sukumar
with the-
Sharma, have you filed any reply? Huh? You have filed an affidavit? You have filed it?
What happened? Not the
There's a stay?
There is no
There's a stay? CRP, what is this CRP for?
there is no
CRP for what? Landlord tenant?
yes, Lord.
Landlord tenant on the ground of defaulter.
Default.
You are not a defaulter.
I have challenged it on several grounds. What happened, Lordship?
No, no.
After
Are you a defaulter or not?
so far my humble submission, I am not a default.
Okay. Both the courts held that you are a defaulter
Lordship. Concurrent bench.
and there is a finding of bona fide requirement.
That was not
Okay. So defaulter finding is there.
there. Lordship.
Now, what is your case that you are not a defaulter? Why?
I have regularly paid the rent of 600. Now there is no issue frame the standard lower court that whether the rent is 1650 as netted by the respondent
Hmm.
or 600. So I have paid the rent 600 in court, and he is staying all along during his lifetime at Guwahati. So the landlord. So there are several grounds. But
No. One ground only. Don't worry. I will give you the happiness of getting a delay condoned and the unhappiness of dismissal of the petition. So both. It's a mixed experience you'll have. Wait, let me see what is the finding. So the trial court held that you never tendered the rent before the court, before to the year, and as such you are a defaulter. So 5/4 benefit you don't get it. Now, what does the appellate court hold? So you have admitted in your cross-examination that you used to pay 4-5 months rent together. So when the agreement initially stated every first week of the month,
It's 1983 agreement, Lordship.
every month from Iman. It
And
falls
Lord,
due
used to
on the
collect it.
first of every month. If 30 days is the learning month.
For the retirement, Lordship, landlord used to decide at what. And that way, used to visit and collect the rent. However, Lordship want to decide the main on merit.
Right?
Kindly allow me at least so that 2 days, 3 days, so that I can follow on.
They just stay.
There is no stay.
Oh.
Lordship,
Who? Learned counsel for? Respondent means the judgment debtor.
degree holder.
Where is this? No, where is this case? Execution case is where?
At Budai. Get no stay from the.
In Guwahati.
No, in Budai. Whatever, Lordship, petitioner for a long time bedridden in Bihar.
You have not been able to execute for 1 year. What to do? Understood. What can I do here? You have not been able to execute. I have made it clear also here that you can go ahead with the execution. Isn't it stated? It is made clear that this court had not stayed the execution of the journal which is under challenge. Then also you are not able to execute. What do I do? Then what do I do? What admission?
No admission. Delay condonation.
No. He is only asking that
For
today
later-
you don't kindly please don't condone the delay and dismiss my petition. That is his request. His request is not that for the fact that condone the delay and admit it.
That
No.
is my prayer, Lordship.
His only prayer is
And
today kindly don't condone the delay and dismiss
no,
my
Lordship.
petition.
I want to correct it. Kindly condone the delay, let the matter.
No, no, no,
merit,
no.
Lordship.
On the same day.
That
Same
can-
day
that cannot be
dismissal.
done,
The
Lordship.
mixed pleasure.
That can be done, Lordship, but
It will be a mixed pleasure. Happiness and pleasure. So don't worry. The question of admission doesn't arise with these type of matters. First day. Nowadays, therefore, I don't find any motion matters before me and landlord tenant. Anyways, at the request of the counsel for the petitioner, matters then adjourned to be listed again on when do you want the death knell to be put? We put it on 18th of June.
my lord.
Okay. Then at the request of the learned counsel for the petitioner, matter stands adjourned to be listed again on 17th of July.
Offline.
May I please, Lordship, here Mr. Ekipuruk is supposed to appear, but he is unable to pay because he is suffering a lot.
What is this
It is
IA4?
an IFO continuation of 159 days.
Huh?
159 days in filing a
Review? Review এখন আছে। ওই একটু টাঙিয়ে টাঙিয়ে মুখ হাত পিকায়। Yes, what is the review for?
First of all, I pray that matter may be adjourned today because Surka is supposed to hear.
There's no stay. Have you, you are landlord?
Yes, I am.
Executed? Mr. The learned counsel for the petitioner applicant submits that he requires some time in view of the unavailability of Mr. A.K. Purkast, the learned counsel who is to lead the matter. On the other hand, Mr. So appearing on behalf of the respondent submits that as far back as on 6/1/2020, the decree has the execution has already been, and the decree has already been executed, and therefore nothing survives. Taking into account the above, at the request of the petitioner, instead of the 6 weeks.
Wait, please, Lord.
Service not complete.
Yes, answer notice.
Petitioner shall take fresh steps upon the respond number 1 to 5 by way of registered as validity within 7 days.
Public.
Yes. Yes, service complete.
I have taken this person in respect of I06 of 2022. I have taken this
Okay. Service complete.
As
Mr.
far-
Sattar, you are appearing for whom? All. Okay. What is the IA for?
I have for condonation of deed of 2018.
And what is the CRP for?
CRP is for Lordship. We are paying for setting aside 2 orders passed in Monitoor order. Thereby, we are not allowing to adduce evidence. Where
Where is that order?
That order is that 2 order Lordship. And it is annexer
15 to
61.
2016, plaintiff has
61.
filed the petition seeking more time till to obtain the copy of the FBI report. Yeah.
61 Lordship.
This is one. And the other order?
And other order is also page 66 Lord.
60?
66 Lord.
66 I've read. The first order is what?
61 Lord.
Yes. Yes, why? Why? Then you are for the plaintiff. Plaintiff evidence was closed.
Closed.
As per the 2015 order.
15 order.
And 2016 order?
Same order Lordship. Thereafter Lordship after
You want to produce some other document
produce.
that was rejected.
Yes.
Very well. What is wrong?
We have available in this document.
Huh?
Right now the document is available with us.
Very well. Can help you.
Lord, that's not. Yes.
4 years you have taken time for.
Actually, I have been instructed to take time by my senior.
Is it?
So I am not in this case.
Who is your senior?
PD family. I have prepared
Huh?
morning.
Chalo. At the request of the learned counsel for the petitioner applicant, the matter stands adjourned to be listed again on. We finish up this week, huh? On 29th of May. 29th of May, no further adjournment. We have to dismiss it on that. We condone
20
and dismiss.
Let it be for 20.
29th. 28th.
20
This is
Lord,
too silly,
maybe
matter.
senior will not available. Lordship may fix either 31 or Lordship 20.
31.
Available.
No further adjournment should be granted.
Good night.
Yes.
This is the transfer petition filed by the petitioner for transferring of the case from Hailakati to Kachar Lordship. Guardianship case.
Hailakandi to Kacha is nearby 30 kilometers. Why do you want to transfer?
59.
Huh? Why? Let us see why you can't go there.
There is a difficulty of going of the
It's
petitioner.
a guardianship case.
Yes, sir.
Where's the kid? Father? And where do you stay? Huh? Hailakandi. Kid is in Hailakandi. So, not possible. This is an application under Section 24 of the Code of Civil Procedure seeking transfer of Miss Bracket guardianship case number 5/2020 pending before the Court of the Learned District Judge Hailakandi to the Court of to any court of competent jurisdiction at Kachar. This court had been inquired with the learned counsels appearing on behalf of the petition party as to where is the minor, the child residing at present. Huh? Who expired?
The son was suffering from
Where is the kid now? Guardianship is asked from where?
with the father, Lord.
With the whom?
Father.
Mother.
Father.
Mother, that is what. We are concerned with that child. That child, that is what I am saying. This court have duly inquired with the counsels appearing on behalf of the petitioner as to with whom the minor, Srimati Miss Dopati Paul,
Yes, sir.
is residing. It has been mentioned that the child is residing with the father who resides at Hailakandi. Taking into account the well-settled principles of law, this court is not inclined to exercise the powers under Section 24 of the Code of Civil Procedure 1908 to transfer the Miss Guardianship case number 5/2020 from the court of the District Judge Hailakandi. Accordingly, the instant petition stands dismissed. The interim order passed on 19/2021 stands vacated, and the parties who are duly represented are directed to appear before the learned trial court on 10th of July.
30.
Yes. It's serious. Transfer from where to where? From where to where? Tinsukia to Kamrup Metro. Why? You stay in Guwahati?
Yes, Your
and he stays in there. What do you do? What do you do?
Honor. Lordship, actually the prisoner was subjected to torture, mental and physical torture.
All understood. What do you do?
Nothing, Your Honor. Nothing.
Huh?
I'm staying with my parents.
You're staying with your father. And you? Okay. What do you want to do? No. Those are this type of no objection. What do you want to do? There are two of either come here or you be happy out there at Tinsukia. She goes whenever is necessary and you pay 4,000 whenever she goes. Which one? Either. In addition to that, she will be entitled to other entitlements. Litigation expense. This will be only transportation expenses. Which one? From? Why? Who is your senior? You should know. This court only does that only. I'll give you two options. You get it on 29th. Get your option instruction. Either 4,000, she will go there. And then whenever it's necessary, she will go there. She does not require to go every day. It is only on the date when the court requires or she has to file any application where she is required to go, you have to pay 4,000. Or in addition to that, she will be entitled to other litigational expenses, 24 and all these things she will get. But otherwise, here, you have to come. But here the problem is, you have to come every day. No lawyer. Mr. So-and-so, the learned counsel, appearing on behalf of the respondent, takes an accommodation till 29th of May 2024 to obtain instruction list on the said date.
It was fixed for it.
Why? Fantastic. That is why the matters come. This is a stay.
Lordship. And 50% is already they have taken.
What is the ground of stay? Ground of challenge?
Lordship, it's an injury case. Sir. It's an injury case.
Then?
Then Lordship, here this is that the doctor, the disability certificate was produced by the claimant, but that was not proved by examining the doctor. And learned member assessed the physical disablement as well as loss of earning at 50% without taking the opinion of the doctor. That was the Lordship, as per second position of law, doctor has to be able to treated the patient, he has to come and examination to the doctor's examination. As per
Doctor has to
Rajesh
examine.
Rajesh, he was not examined. Disability certificate was produced, but that was not examined.
And if the doctor dies, what happens? What happened? If you are saying that is the law can't be unreasonable.
Yes, Lord.
If the doctor dies, or the doctor says, I'm not going to. I've treated him, but I won't go. Then?
Expert opinion. Expert opinion.
Any expert. So that becomes
Yes.
better. Huh?
Yes.
So if the question is without an expert opinion, the trial court had come to a
Yes,
final.
I'm sorry.
I think that is a
Yes,
better.
that is the proper.
Yeah. You want when? Why? Next week? No, not no. The learning council appearing on behalf of the respondent, Mr. And so request for an early disposal of the matter, taking into account that the claimant is suffering. Who's taking into account the above, list the matter on 18th of June.
Lord.
For hearing. LCR has come in that matter. Yes, service complete.
Lordship, service is complete, LCR is also there, but if the Lordship,
Service complete, LCR is it's the matter for.
Your Lordship.
Hmm.
If with the concept for the insurance company has agreed, if it is the appeal of 2022, the appeal can be remanded back to the tribunal for deciding appeal. And
Let
the-
it be
and the-
done. I am not, Mr. I am not a regular of this
Your Lordship,
appellate matters.
Your Lordship, this Kumari Tulu is the mother of the child, and he is only surviving legally. So if some delay is there in disposal of the appeal, everything will go. Because I have the appeal has been dismissed.
Same matter to
Dismissed before the trial court.
List the matter again on 29th of May. I'm not passing any order because you see, then the regular bench is sitting. I won't be. I don't take up these matters. No, it's not.
Hello, please.
Yes. What is this?
So it's the application for contradiction.
Huh?
Petition of the legal error
They have to retain something.
service complete.
Wakalatnama has been received from the record number 1 to it is filed instead of filing IA 2400. They filed it in CRPI. So service is complete.
Complete. Your- On behalf of respondent 1, 2, the service is complete.
Then?
Now
Then what remains?
petition for.
How many are there? Service complete.
And Wakalatnama has been filed on it.
Hmm?
Wakalatnama has been filed in behalf of respondent 1, 2, for whom we have taken the service to us.
Others have appeared.
Others have the
You are
performance-
paying for others? You. What about the others?
Others are not appearing in the.
They are not.
Yes.
Service is done.
Yes.
How do I know? Let the registry list the matter in the first week of June 2024, indicating as to whether the service upon all the respondents are complete.
In this case also, the LCR is arrived. Matter may be at for hearing.
What is this IA for?
IA is for the lordship, Injunction lordship. And in that way, got a
And what is this CRP?
CRP.
CRP for what?
There's been order dated.
Huh?
There's been decree dated 25/11/2016, passed in title suit number 4110 of 2013 by Learned Mufti number Complement.
Where is it?
And except for your page number 35.
Why you are filing under 115?
This is under specific relief act.
Why do you say so when you are asking for declaration?
The Todi Patta land you thought.
Cozy Patta land, whatever may be, this cannot happen. Declaration that the plaintiff is in Iman possession of the suit land and the plaintiff has been evicted forcefully and illegally from the Iman, recovery of past possession, permanent injunction. Then This is not a suit for the year, section 5. Suit for declaration. This is a declaration suit under section 6 of the Specific Relief Act. It values the suit is- But declaration was in the plan. That cannot be a ground. When was the suit filed? 2013.
November 2013.
You're appearing for IA for what? Injunction.
Injunction, Your Lordship.
Okay. Mr. P. Sharma seeks for an accommodation of filing a reply. You want to file a reply or not? To the instant application. This is the matter of the 4 weeks.
Lordship, the interim order may be continued, Lord.
This is the matter on 30th of July, 29th of July 2024. Interim order passed earlier shall continue.
But
Yes, service is complete. You are paying for all the respondents? Sold. LCR has been received. Okay. Service is complete as well as the LCR having been received. List the matter for hearing in its usual course. Parties are given the liberty to file applications for early hearing. Go to the registry. They will put everybody. Yes, service is complete. Respondent number 2, somebody has received.
The brother has
Served and brother of the respondent received. Huh? When? Mr. B. Kaushik, the learned counsel appearing on behalf of the respondent numbers 1, 3, 4, and 5 submitted that the respondent number 2 had expired on 28 March 2022. The learned counsel appearing on behalf of the appellant submits that she would take appropriate steps. This is the matter of the 3 months. What about the other side? You know, LCR have been, the respondent being duly represented. You are paying for all the respondents? Okay. There's a stay? How file this case? What is this matter about? For land grabbing. Land grabbing. You want to you list it for admission? List the matter for admission immediately on 22nd of July 2024. Full stop. In the interim order passed earlier shall continue till then. Yes, what is this?
My lord, IA 900, my lord, prayer for release of 60% of the awarded amount.
Yes, objection. Why? Your objection is not on record. Where is the order? Mr. Archibald, the learned counsel submits that the objection has been filed to the application. However, the same is not on record. List the matter again.
My lord, it is on record, my lord. It is on record.
It is on record.
Yes.
How much is the amount? How much is the amount? Huh? Uh. Uh. Hmm. Hmm. But where is the direction for payment of 60% where?
No,
I'm not finding any.
that is not yet passed, my lord. I filed the application.
Now, whether there is a stay? Who has filed?
Stay is there, my lord. 13/2/2000.
In which case? IA?
My lord, in 3,734, my lord.
Huh? 334.
Hmm.
334.
Yes.
Okay. Issue notice to the till next day operation of the judgment and award is state.
Yes.
Okay. So now he wants a vacation of this order.
No, I am not pressing for vacation of the.
Then
I want, my lord, to release of the.
what is this? You have to ask for vacation, then only this court will matter.
First, my lord, first I paid for vacation you by 631.
But I'm not getting your reply. Hello. Let us have it here. Okay. List the matter again on 29th of May 2006. 31st of May. No, not for hearing. Let it come up on before the usual bench. Yes, what is this? How much?
622 days.
Yes, you have filed reply.
Yes,
Why?
626.
On donation of what? In what way? What is this? Matrimonial. Matrimonial. Huh? No reasons given. Hello, we'll have it covered. Is the matter again on 3rd of 5th of June 2000. Yes, what is this IA for? Complete stay. The stay stay has been made here.
Not yet, not,
How it
Not-
mean to get? This is under 37.
not yet. Under 227.
Huh?
227.
How are 227 is going on?
Yes, document fix
Considering
is
the
on 30.
submissions made for the
document fix the
arbitration
entire matter on 30.
so which is pending before it will remain state. Why should it be stayed?
Lordship may fix the matter on 30. Lordship will
Why?
fix it.
227, why arbitration?
Lord.
My goodness. When do you want?
30. Please do.
No, okay, 30. We have it on, no, 29, 31st. We have it on 31st. Only consideration is how much cost I should impose upon you. Nothing more than that. Forget about the stay to vacate, dismiss. Now the question is cost. That is the only instruction you take. Starting from what is your claim?
He has not finished his work, no.
2 crore 49 lakh. So we start from 1%. At your cost. 2 lakh 49.
As per office note dated 21st
41 we get
2024, service awarded load, open respondent number 1428.
Yes, what is this? Service can copy of the LCA received, service for the event. What about that? You are paying for whom? Why? Service is complete.
They have, they are saying that they have filed a would say they are not. If they are not delay,
Which order? Which order?
Page 42 load.
Huh?
Page 43 load.
40?
43.
43. Okay. You are for respond number, defend number 4 and 5.
Defendant number 1 and 2 load.
Who are you?
Abdul Aziz.
Your written statement 1, 2, 3, A to 3C. Is that? What's wrong with it? Okay. Now, this is an application under Article 57 of the Constitution challenging the order dated 4/1/2023 passed in title suit number 148 of the 2022 by the Court of the Learned Munship number 3 Dhubri, whereby the written statement so filed by the petitioners herein, who are the defendant numbers 1, 2, 3A to 3C, was rejected on the ground that the said written statement, though filed, but having been filed after 90 days, cannot be accepted, and as such, the suit shall proceed ex parte against the state defendants. This court have duly taken note of that. Yes, what is your ground?
Ground lordship I have started at page 9 load.
Yes, what is your ground?
I have submitted with the delay condemnation delay.
Whatever delay condemnation, you are not concerned. Why you could not file within 90 days?
That was some difficulties lordship. Page 9 lordship I have started.
What is your difficulties? Tell me.
Page 9 paragraph B lordship. I have stated for that the summon was received by the petitioner defendant on 13/7/2022, but the documents relied by the defendant plaintiff was not furnished to the petitioner. Moreover,
When?
the civil vacation was started with effect from 6 October.
Those can't be the ground. List the matter for admission, taking into account that the service report, list the matter for admission on 3rd of June 2024. Interim order passed earlier. Mr. Counsel, you have to be ready with your file. If you want a disposal in your favor,
I'm applying.
yes. For this matter,
I filed my affidavit for the service.
yes, what order has been passed?
Held under the doesn't have the territorial jurisdiction.
Huh?
So held at the court of Karbi Anong doesn't have the territorial jurisdiction.
So nothing remains.
But the copy of the copy I have not obtained.
So that order becomes infructuous. Anyway, Mr. G. Alam, the learned counsel appearing on behalf of the petitioner, seeks for an accommodation who submits that to his information. The learned district judge Karbi Anglong had passed an order holding that the said court did not have the jurisdiction. He, however, submits that he has not yet received the certified copy. So taking into account is the matter on 31st. So your job is done without any. But in another case, if this case would have been, he would have passed otherwise, I would have held that the court had the jurisdiction. Because of the fact, understood, for the child it is okay. But for a child to have the care of the mother in absence of the father also is of paramount importance, and as such, wherever the mother files can have the jurisdiction. I would have held. That was my opinion. Otherwise, the Supreme Court says it's a different statement. I hope the other side challenge it. Yes, Mr. Arch. What is this?
For this past I for the honor of the clear lot with the 703 days.
703 days. And you wanted this upgraded in the morning? Huh? You wanted this initial, means the dismissal should be in the morning. Yes, Mr. Teka, what is it? Para 6 of it. Huh? 424, para 6. The engaged counsel has misled and negligence to conducting before the learned trial court, despite the learned trial court does not instruct to the applicant to file it affidavit on the. Yes, who has drafted this? Who has drafted this petition? Who doesn't know hello tale about English? English is far away. We know that England is too far away. Then also English happens to be our court language. What is this English? Yes, Mr. Deka, kindly read it so that everybody may have some laugh about. What type of English is this? Applicants beg to state that the engaged counsel for the applicant's defendant had misled and negligence to conducting before the learned trial court. Despite the learned counsel does not instruct it to the applicants to file written statement, affidavit on defense prosecution, and adduce evidence as exhibits before the learned trial. Therefore, the impugned judgment in Maya arrayed ex parte on so and so by the Iman, reason behind negligence part of the. Have you filed any application against the lawyer? Then you can't make this type of allegations. But anyway, we are not concerned with that. But how are you condoning the delay?
That is the piece fitted to the internal principle.
Huh?
Piece fit.
No, not page 22. What is your explanation here for a delay?
The counsel of the negligence of the counsel for the not of the evidence of.
About the judgment?
Yes, sir.
Where is that mentioned? The counsel suggested to approach this court to institute an appeal and the applicant conceded to come at Guwahati on 20, intimidate with one, this can't be taken. There's no English at all. Sorry, Mr. Paul, ask somebody or you draft it properly. This is not the, you can't draft it in. No, absolutely no. Your petition has to be more clear. It can't be in this manner. One doesn't understand head or tail. Even it will be difficult for him to reply. Isn't it? He would be thinking that it is something else. He would make a reply and at a later stage, you may say, we meant actually this. Absolutely no. This court does not go on the question of negligence on the council unless you file any application. And secondly, negligence of the council, you can't make it a ground. Unless you show that there is so much here, you make him a party or do something. I'm not going to do that. You can't put a judge up, blame the council. This is the habit out here. I don't encourage it. I have given 6 judgments. Negligence of the council cannot be a ground. So I am bound by my judgments. So if that is the only ground, then 703 days appeal goes for a 6. Huh?
So, concern of the detail of the continuation motive, the court is that distribution power to confirm the detail.
The Supreme Court also said recently that if there is even a sufficient cause, but there is negligence, the lack of diligence, even there is a sufficient cause also, then also not to condone that. That is also the. With this English, I am not going to do that. No, he's blaming all his lawyer. Unless you do anything. And what were you doing? Huh?
There is no contest. Only case 22. Of the entire evidence of the plaintiff, it appears the plaintiff able to prove his case by the existing oral and the documentary evidence that the defendant side pro appeared before the court, but they did not file their written statement.
You, Mr. Paul, this is not, Mr. Das, this is not the type of English I will entertain. I am not here from 3 to 14. So better off try it before other courts. And after that, if I come back and get this thing in this manner, it's sure dismissal of your IA. Then you need to go to the Supreme Court. So better improve it before I come, or what do you want? For what? For what? Money decree. You want the money from them. You filed a suit. Oh, what is the money for? Okay.
What is the due to the riot 40? So in the year 40. So as per the agreement 40, that every year the evidence paid for. The active the 12.
Sorry, Mr. I am not going to do it.
12 40.
Next. This is the matter. When do you want it? Short date. Okay. 5th of June. Let it be before some other. With this English time.
So I have to rectify what?
Huh?
Rectify.
You file an additional affidavit or something. You want to file an additional?
Yes.
Mr. Asidas, the learned counsel submits that in view of the language employed in the application for condonation of delay, he would like to file an additional affidavit. So, taking into account the above, list the matter on 5th of June 2024. In the meantime, he would be at liberty to file an additional affidavit by 3rd of June by serving advance copy to the other side. Yes, what is this? Delay for how much? 97 days. You are appearing? Okay, we condone it. 97 days is too late. How many are there? What about the others?
Service not complete.
Complete. Don't list the appeal, accompanying appeal, and list the admission in. আগৰখিনি লিখি দিব হা সুধি ল'ব There is an application under section 5 there is a delay of 97 days in filing delay this court finds sufficient ground perusal of the application shows that the grounds mentioned therein constitutes a sufficient cause within the meaning of section 5 of the limitation act according the delay stands condoned the registry shall register the accompanying appeal and with it in the stage of admission.
But my name may be good. Otherwise, sorry, not it.
Where?
And the speech mentioned in the
Oh, there is a registry out there for that. 56 days. First day.
48 days.
Huh?
48.
No, 56 days. Anyways, the first date.
First.
Oh, notice 6 weeks, 3 days steps. Raise the eligibility.
Madhu.
Yes, what is this matter? Mr.
Matter.
Mr.
It's an
Chaudhary, I see
injunction
you so
matter.
late on a Friday.
Ah.
What is
My
this
lord, do we
matter?
have filed an application for vacating the stay order, my lord?
What state?
Initially, my lord, there was I am the defendant, my lord. The other side is the plaintiff. Initially, there was an order of injunction. Against that, we preferred an appeal under order for 1 hour, where the injunction was vacated. Against that, the plaintiff has approached this honorable court under where on the date while issuing notice, stay was done.
Directed
there is,
and no
there is no
construction.
finding regarding any prima facie case. There is no schedule. The court, the London trial court itself has been. And my lord, I have also given an undertaking in your objection that end of the day, if they succeed, we'll demolish everything. Because we are undertaking some construction. I brought the relevant photographs also, my lord. Lord, kindly come to page 96 for a moment. This was the objection which we filed. Para 40.
Para?
Para 23, page 96.
Yes.
That moreover, it is also humbly submitted by the office before the honorable court that OP number 1 by this written objection undertakes on oath to demolish his RCC building being constructed if at the end of the title the same is at all found to have been encroached either into any part of the 8-feet common road or into any part of the petition.
Now, tell me one thing. This building you are going to construct now,
Yes.
are you going to create third-party rights?
No. No.
Wow, what are you constructing for?
Own house, my lord.
Own house?
Residential. My lord, we are brothers. The plaintiff and the defendants are
What
brothers.
is the plaintiff's case?
My lord.
What is the plaintiff's
My lord,
case?
plaintiff's case is there is a lot. I have given one drawing, my lord. The lordship should have the counter which we have filed in the
Cancellation of the sale deed, correction of the revenue record, and injunction.
if a lordship to kindly take page 46.
A decree be passed declaring the right, title, and interest of the plaintiff of the decree declaring the registered sale deed is void, illegal, fraudulent, and liable to be cancelled. Construction violating the mandatory guidelines. Who is in possession of the suit land?
We are possessed.
Then why are you asking
Actually,
for plaintiff's peaceful enjoyment of the suit land?
So, but if a lordship to kindly come to page 46 for a moment. My lord, we are possessing our part of the land. Any endorsement on anybody.
You are asking for recovery of possession.
No. No.
Who is filing the counterclaim?
It is there. We have filed a counter.
So you are asking for recovery of possession?
Recovery of possession from the plaintiff. Recovery of, they are asking, no, that is a different, we have filed a counter claim because
our land is being occupied by the plaintiff. We owe 5.5 lakhs from the plaintiff.
Instead of their case in the plaint is that we have enforced upon their land, but in the my lord counterclaim, we say it is they who have enforced upon us. That is why they counter. My lord, everything will be clear if your lordship to kindly have page 40.
Yes.
That's the drawing sketch map which we have
46.
46.
46
It's
is
part of our my lord
no 46 is no drawing.
counter affidavit in the counter affidavit. Filed by
There is a counter affidavit.
in the IA.
Yes. 34.
Kindly see, my lord. Kindly see. Right hand side is the plot of land which belongs to us. It was given there.
You are Jahangir. Jahangir is who?
Jahangir is the plaintiff.
Okay, it will be appellant, all parties, Shahjahan Sikdar.
Sikdar.
You are Shahjahan Sikdar.
Shahjahan Sikdar, yes. Kindly see, my lord, between our land there is a boundary wall.
Partition boundary wall.
There is no question of encroaching anybody's land, my lord. And kindly see, my lord, what they are claiming is a portion of the land within their own part. That is their, my lord, the plaintiff.
Now, what is this page 34 of their application? This there's some construction going on.
Yes, my lord, I'll just show the photograph, my lord. Yes, we are making construction in our own land.
No, this is page 34
of the
Annexure 2 series that I
have filed by. Yes. In fact, my lord, this is a very distorted photograph. These are the clear ones. Thank you. This is the actual photograph.
This is not residential. If you are speaking about this construction,
yes,
this is not residential. This can't be residential. You are having a next.
My lord, these people, these areas do not have any, my lord.
No, why I'm saying no.
Yes.
There's a reason why. Tomorrow you may give an undertaking that I'll demolish it if you lose the case.
No, my lord,
But if you create third-party
no,
rights by way of tenancy or
my
any
lord,
sale,
it is regarding the land which is on the other side.
no, where is the
Their
construction?
claim, my lord, let them satisfy according to the plate, which is the disputed plot of land, and how the court below could have granted an income.
Okay, let me hear it on 28. 28 we dispose it of.
Okay.
Yeah. You're not there?
Will it be inconvenient on 29?
29 it's
Yes.
okay. I will have it on the top of the list.
Yes.
He has a difficult. 28 also there's a division bench on there.
And
I've got so many matters this last week fixed up.
my lord can have it on 31st.
31st, okay.
Yeah.
31st at the top of the list. And the list is matter on 31st in the stage of stay vacating.
Yeah.
Stay vacating is what type, huh?
No, my lord.
At the top of the list.
Ah.
So top of the stay.
49.
कोई हेरी को काइले वो डिवीजन बेंच का सिंगल बेंच नहीं है yes what is this oh Mr. Das what are you doing so late in the day the divorce case huh How got this matter got listed today?
I don't know. By order it seems.
Dosto, you mentioned before which court? First of all, hearing matters, how can it be listed in this manner? Can't be. It should be not before me. I don't permit. Huh? No, no, no. This is not. The divorce case was, who filed the divorce?
The husband filed. I have,
Okay,
I
that
have
was
not-
dismissed. Now he has filed an appeal.
Yes.
Then why is the wife asking for an early disposal? She wants a divorce. Then no chance of this compromise
There was an
or
attempt,
mutual. There's no
there
chance
was
of.
an attempt by the High Court. But she did not come by.
No, there is no order passed that the matter be placed before the mediation.
Yes.
Oh.
It was.
In view of the matter is adjourned, meanwhile the mediation may go on as per the convenience of the party. 1411. Then
There were three occasions he did not come. He did not appear before the petition.
the appeal was admitted.
Yes. It was before the before that it was before the defeat.
If the mediation is done, I think it is better. All this while sitting out here, I have not disposed of one matter of this matrimonial.
It is really something painful to grant it to of the fruits of this couple. They are the young couple. There's no issues.
No, marriage, it only happens then, no? The case of cruelty.
Yes.
He asked for cruelty.
Yes.
It could not be proved. Hello? Yes, any date you want, we fix it.
If it was Lalfeld, what colored
Well, any event after vacation, July.
after it?
No, I actually, this is not my bench. These matrimonial appeals, I don't take it. It's the other bench to take because today Justice Parthiv Jyoti Saikia did not sit. Therefore, you file this, the motor vehicle matters, these matters are before me. Sometime in the month of July, let us have it on 23rd of July. Is it okay? It's a Tuesday.
After July.
After July. The June is still there. 22nd, 23rd of July.
No, July, well, I may get extended the package.
Okay. Hello. Can we have it on 18th of June if you are not there?
18th, 19th, and 20 minutes, other matter. It can be on next week of June.
25th?
24th.
25th of June?
Yes.
Of the agreement between the party, the matter be listed on 25th of June 2024 for hearing.